Good afternoon, all. This hearing is in the matter DEC 001-2025 and is being held by way of video conferencing before His Excellency Justice Michael Black, KC, with the sitting of the hearings taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al-Tamimi and Company. Lead counsel is David Holloway. The first defendant is represented by Quinn Emanuel Urquhart and Sullivan UK LLP. Lead counsel is Mr. Tom Montague Smith KC. The second defendant is represented by Hadif and Partners. Lead counsel is Adrian Chadwick. The third and fourth defendants are self-represented and are not present in the hearing. Thank you.
Your Honour, before we start, there is one preliminary matter, which is whether or not this hearing is heard in private. And at the moment, so I obviously act for the first respondent, Aria Commodities, and we would ask that you do sit in private in relation to this. And I've raised that with my lone friend and for the claimant, and he says he does not agree. So we will need to have an argument about that.
Mr. Holloway, applications of this nature are normally held in private.
My understanding was that an ex parte hearing would be heard in private, but not necessarily the return date.
No, I think this should be heard in private because, frankly, no decision has been taken on the merits and the potential for reputational damage and the impact on other proceedings of matters that are being dealt with on a purely contingent and interlocutory basis far outweigh, it seems to me, the interests of an application like this being heard in public.
Very well.
So this hearing will be heard in private.
But thank you, Your Honour. There's obviously one other matter, which is that the second respondent is present.
Yes, Mr. Chadwick, who hasn't turned his camera on.
I don't think he's planning to say anything because, as I understand it, there's no application being made against his client today.
No.
I asked him whether he minded unceremoniously being booted out of the hearing, and he said that he's obviously curious to find out what this is all about. I mean, I'm sure that the bank can be trusted with the information, but clearly this is highly sensitive stuff. And if he's not going to be actually engaged on any application today, we're not sure that we see the merit in the second respondent being present either. But I'm
not with you on that one because his client has already been served.
Well, that's right. With some material.
Yeah. I think the bank has a legitimate interest to be involved in this proceeding since it has been served as a party. And of course, as you say, I'm sure we can rely upon the bank and Mr. Chadwick's professionalism to respect the fact that this is a private hearing.
Of course. And I wasn't, to be clear, I wasn't suggesting that we couldn't.
No. I understand your position, but I think whether Mr. Chadwick is booted out unceremoniously or otherwise is not going to occur. Thank you.
Thank you.
So look, I'm grateful, my lord.
Can I just say a couple of things? So today is a relatively short hearing. As a point of order, Mr. Holloway, it's my understanding of a return date is that the ex parte injunction lapses, and it's for the applicant to justify the making of the order inter partes. It's not strictly necessary, therefore, it seems to me, for a respondent to issue an application to discharge an ex parte order, although it does seem to be, to me, always has been good practice, perhaps, to issue an application to discharge, particularly if, for example, one is alleging that there was originally material non-disclosure and the ex parte order should never have been made. So we can perhaps deal with that in due course. But having said that, as I understand the respondent's position from the skeleton arguments, it doesn't ask today for a discharge of the order. but seeks variation in three respects. Variation of the order in relation to the proprietary nature. Secondly, fortification of the order. And thirdly, directions. Can I deal with directions first of all, if I may? The first direction sought is that Aria Dmcc will serve evidence in response by 4 p.m. on the 3rd of April 2025. Is there any issue with that, Mr. Holloway, particularly since obviously Eid intervenes?
Well, I think the issue I would have with it is not the timing, but actually the point of principle that an application should be made and should have been made for these orders that are being sought. And I'll just make a couple of points on that, if I may.
Yes, I mean, I can tell you're having an uphill struggle on that, but I mean, it seems to be a distinction without a difference in any event, given that the application today is not to discharge.
Well, it's, I think it isn't just a matter of good practice to make an application of the nature that my learned friend tries to make. It's stated in the order at paragraph 19 that any party wishing to vary or set aside the order should apply to the court. It's not, that would not necessarily be taken to mean that you just turn up the day before the court hearing with a skeleton argument and some completely new arguments in terms of applications that are being pursued and evidence being served on the night before the hearing. I think that the next point I'd make is you yourself in the transcript of the hearing referred to liberty to apply being the position if the respondent was dissatisfied with certain aspects of the order. And thirdly, it simply is standard practice that an application be made. I've got some authority on that from Stephen G's textbook. We can go through that in due course. But in short, we've made an application to continue. And what I'm going to be saying to Your Honour today is that there wasn't any opposition to that, and that the matters have been put in. You know, an application could have been made and should have been made, so it wasn't. And if we're trying to speculate about directions for a future application, I think the application should be properly made with proper evidence, and we can.
But I mean, Mr. Holloway, I think we're arguing about the length of the Lord Chancellor's foot here. I mean, we know why we're here. We know what we're trying to do, and you know, I think we should focus on the practicality rather than the how can I put it, strict formalities. If you're telling me that you're prejudiced in some way by the procedure, that's one thing. Obviously, I won't permit you to be prejudiced. But if you're saying that for the want of a piece of paper, I shouldn't be considering the merits, I think you're banging your head against the wall, frankly.
It is a point of prejudice in the sense that what my learned friend has done is, throughout the week, they've not come forward with any proposals as to what we're going to do at this hearing until Thursday or Friday. They've not applied to adjourn our application. What they've done is to say, well, we're not adjourning the hearing, we're going to adjourn your bits of the hearing, the continuation bit. And in the meantime...
But as far as I understand, there's no opposition to the continuation. We're just going to be varying it. So what's the problem with that?
The problem is that if we're agreeing that the injunction continues in the state that it was made in the form in which it was made, less of a problem. If we're saying, well, we're not going to hear the merits because we haven't put forward our case on that, we'll challenge it later. But in the meantime, we're going to have two applications on the fly with completely unsatisfactory evidence for fortification and for variation. So it's two bites of the cherry. And I guess my submission is, if we're going to have a proper return date, all of those matters need to be considered at that hearing. We don't get to do Mr. Montague Smith's bits today and then our bits later. There's no.
Honestly, I'm not sure I follow. I think there's a difference between the variation of the order and the fortification of the order, and I can tell you where I am from a preliminary point of view. So far as the variation is concerned, that appears to me to be pretty urgent from the evidence that's put before, because this is a trading entity. They put forward evidence that suggests that there are elements of the ex parte order as made which are having an impact. And you know, I recognise that this court is not even seized of the substantive matter. The court is acting in a supportive way for the Hong Kong proceedings, and consequently we're at a couple of removes. That's one thing, and I think you go a very long way. You have to go a very long way to persuade me not to deal with that today. So far as the fortification of the order is concerned, I think that's different. I think actually there is arguably prejudice to you in relation to the fortification of the order, because I do think you need the opportunity to put evidence in relation to that, particularly as to the finances of your clients, the practicality, whether you accept there should be fortification or not. All of that I accept may require a bit further time, and subject to Mr. Montague Smith persuading me otherwise, it was my intention to adjourn that application to the hearing to take place. I'll come to the dates in a moment, but I was minded to hear him on the variation of the order today, because that did appear to me to be urgent.
Well, what I would say then is we wouldn't be averse to that, but I would propose that the order should be that I pursue the application to continue, and I'll deal with the variation in the course of those submissions.
Well, you take your own course, but we have 2 hours. It seems to me that there is no opposition to continue, subject to the variation, but I'll hear from Mr. Montague Smith on that in a moment. But what I wanted to do, first of all, I didn't realise we'd actually have to take so much time over it, was just to try and fix the dates for the service of evidence and fix the date for the adjourned return hearing. So I'm going to come back to that, if I may. Is there any issue with the 3rd of April for Aria Dmcc to serve its evidence?
From our side, of course, not.
Okay, good.
But caveat, they've had the order since the.
Well, if there's no I don't care about caveats. I mean, if the date is okay, Mr. Holloway. Mr. Holloway, if the date is okay, the date is okay. All right. So let's move on. And are you content for your reply evidence on the 17th of April?
I was sorry, I was jumping ahead to that, Your Honour. I didn't mean to speak across you. I apologise. But the point I was going to make is the 3rd of April will have meant that Aria have had.
So you're I apologise for interrupting. We've got 2 hours for this hearing. My learned friend's taken 17 minutes of it so far. I know. Tell you about the 3rd of April. I've got submissions I have to make to you, Your Honour, about the proprietary order. And if we've got a hard stop in an hour and 43 minutes, then my learned friend has had a whole ex parte hearing to tell you his case. And in fairness, I need time to tell you mine.
Yes, I have some sympathy with that. Mr. Holloway, we seem to be making very, very heavy weather out of matters that I thought we could deal with. Mr. Holloway, let me speak. That I thought we could deal with quite quickly. Short question. Are you happy with the 17th of April? If not, when?
Yes, we're not happy with that, Your Honour, because that would have meant that we have 2 weeks to respond to an application that has been and evidence that has been 5 or 6 weeks in preparation. So we'd ask for a bit longer than that, an equivalent amount of time than the first respondents had to put the evidence together.
So what are you suggesting?
2 more weeks.
2 more weeks?
Yes.
Mr. Montague-Smith, what do you say about that?
The return date needs to come on quickly, because it's not just the proprietary order will be terminal for my client, and I will make that case. But a freezing order, even subject to a business use exception, is still a huge fetter on the operation of a trading entity like this, because of the way the banks will react to it. And we may well have to come back to you in light of our experiences with the banks in due course. My learned friend's saying he needs 6 weeks or whatever it is, or 4 weeks to respond to this evidence. He's had time to get his evidence together. He's put it all out there. We're simply responding to his application to continue. And the ordinary thing would be that the reply evidence would come much shorter. So the idea he needs the same amount of time as us is not fair.
Okay. Look, let me just work back, because the first 2-day date that I can give you, with a 3rd day in reserve, would be the 5th, 6th, and 7th of May. I actually got a hearing in England, and then a court of appeal case the previous week. So every day is busy that day. So I mean, I can tweak it. I can tweak it slightly. If we say 17th. I'll give you to Easter Monday, to the 21st for your response, Mr. Holloway.
Thank you.
And then I will fix the hearing for the 5th and 6th of May, with the 7th in reserve, but not to be used unless we have to. Does that work for you, Mr. Montague-Smith?
Sadly, no. I've got a hearing on the 1st and the 2nd, and then I've got a hearing on the 7th. So trying to put a heavy hearing in between those two will simply not fit. I think the earliest I can do is likely to be the 12th. Is that something?
Well, I can do the 12th. So I'm happy to fix it for Mr. Holloway. 12th work for you?
Do the 12th, yes.
Sorry?
I can do the 12th.
Yes. Okay. Well, let's fix it for the 12th and 13th. With, as I said, the 14th in reserve. That should give you plenty of time to prepare. Okay, good. We've got that done. Okay, I do need, I think, to hear Mr. Montague-Smith, given the urgency of what he says is the position. So, Mr. Montague-Smith, do go on. Do go on to the variation.
Thank you.
And we've not necessarily got a hard stop at 10 o'clock UK time.
That's helpful, and Your Honour will appreciate that. I mean, this isn't the usual run of freezing order applications. This is a situation where we say the effect of the order has been to shut down the operation, and I'll develop that. Just though dealing with whether or not this is my application, this is my learned friend's application. I'm responding to my learned friend's application here. That's the position. His evidence, he's made it. My evidence has gone in response, and then he needs to tell you, he needs to explain to you why this should be continued. But his case, why it should be continued, is effectively the same as his case for making it in the first place. As to fortification, Your Honour, we'll get onto that later. But the position is that my learned friend should have come to you explaining to Your Honour why he didn't need to fortify. That's the normal and ordinary approach. So you give the cross undertaking, and then you need to satisfy the court that you're good for the money. And so ordinarily the court will say, well, where are the accounts? And you will show them the accounts, and you'll show them that there's money in the jurisdiction. Or you'll say the strength of the claim is such because I've already got a foreign order that in itself can stand as security for the claim, but this is not that sort of case. And so we do say.
I'd rather thought that that would happen after today.
I mean, I understand pragmatically why Your Honour might say that, but in the meantime, we are suffering losses. So, for example,
that I fully understand. I mean, their argument is that they're entitled to damages of the order of £500 million against you and have a good case. But there it is.
Well, I understand that, and we'll deal with that, and I can take you through it. But and just having a good case is not enough to say I don't have to give fortification.
No. That is
not
true, because the court can't, obviously, as I say, particularly 2 steps removed as we are in this case, come to any real conclusion about the overall merits.
Well, that might be right, but actually the court has to take a view on the merits in a case like this, because
well, yes, on good arguable case basis, not
no more than that. No more than that, because essentially, well, because it's the American cyanamide case. And on a proprietary injunction, the court has to ask itself the question: what are the relative merits of the case? And that the authorities say that, and that's why, for example, when you get to the mandatory injunctions and prohibitory injunctions, and people say, well, you need to have a high degree of assurance for a mandatory injunction, and then Lord Hoffman in Films Rover says, no, that the difference is not between mandatory and prohibitory injunctions. The reason that people sometimes say that about mandatory injunctions is because they are very often more likely to cause harm. And so when you have an order which is very likely to cause a lot of harm, you really have to be clear on the merits. And that's why they say you need to have a high degree of assurance before you make an order of that sort. So I can show you that if we need to. But ultimately, at this stage, this court, Your Honour, does have to take a view on the merits and ask yourself the question: given the harm that could ensue from this order, am I sufficiently confident in the claim to be able to take that risk? But let me develop that, if I may.
Yes.
So we've set out our position in writing, and the way that I would characterise this application, and I say this advisedly, is that this is a reckless application. It is reckless. You were not given anything like a fair picture of the situation at the last hearing. Things that were known by my learned friend's clients were not disclosed, and you were told things that were false. And the order, we say, has caused already very substantial harm. It's stopped an investment group in its tracks, and that has very real implications for real people who are not connected, who are not in any way implicated in this case from doing their jobs. So, for example, there's a bitumen plant. There's over 100 workers who cannot be paid for their jobs for that. That plant will have to shut down. And that will have real life health and safety consequences. And obviously there will be regulatory consequences if that continues. There are mining operations which will have to stop in their tracks as a result of this order. And we say, as a matter of principle, parties should not be asking, and this court should not be ordering, businesses to shut down. We do say this is a wholly artificial claim, and fundamentally it cannot work unless the claimant is able to show that the fund and the claim and the defendant, or the first respondent, are a sham. So this is the fund is a fraud case, and I'll develop that and I'll explain that that's what they have to show, and I will show you the material which shows that is not arguable. It's not reasonably arguable. And with great respect to my learned friend, we say that the ex parte presentation was just very far from fair. But despite that, we say the argument that the fund is a fraud is not properly arguable today. My learned friend should not be putting forward that case. I say that advisedly. I've got a lot of time for my learned friend, but this is way over the line. My learned friend now admits that you were falsely told at the last hearing that there were no audited accounts for the fund. And he now accepts, in fact, there were audited accounts for that fund. But now he says, oh, well, there's all these other points that we'd like to take about the accounts. And he submitted a further affidavit on Friday in relation to that. He did that without any warning, without any explanation as to the timing of that. He doesn't say when the error was identified, when the decision was made to correct that. So he put that in on Friday. The version, though, that he wants to advance today appeared in his skeleton argument, which he originally wanted to exchange on Thursday. So it looks like that affidavit was available on Thursday, at least, probably before. The mistake must have been identified before then. We don't know when. Perhaps he'll tell us. But it wasn't told to us, and it wasn't told to the court until Friday. We have managed to scrape together in the time that's available evidence in response to that. Most of the points that are made there, some of them, not all of them. I hope that has made its way to you. It's in the bundle now. So Mr. Britton has put in a third document, which is his second witness statement. It's at the end of the bundle.
I have, yes. I saw the second witness statement this morning,
Yes.
and the exhibit to that. So I've skimmed it. I haven't read it in huge detail.
I'll take you to a couple of pages from that, and show you that the criticisms that are made by my learned friend. So, for example, he says, "Oh well, there's a disclaimer at the end of these accounts, so they can't be trusted." And so we show you why the disclaimer is there. We've been able to go back and find the email from the accountants and explain why there is that disclaimer in there. But I will deal with that in a moment. But if you've had a chance to read that witness,
yeah, I saw that point.
Yeah, and the information orders themselves have caused huge disruption to this business. And we've completed that exercise now. And again, I don't know whether you've seen this, but late last night, the information, the complete information was provided.
There was a letter from Quinn Emanuel, I think, that came into the registry.
That's correct. And there's a new schedule that is attached to that. That has been a huge undertaking. Essentially, the effect of that order is that the DMCC, as I'll call them, which is my client, and the fund have had to undertake what has been in effect an entire audit of their operation in order to get you that information, and try to work out where that initial cash, which was received up to 4 years ago, where that has gone. This is a group of trading entities, and so the effect of the order that was made was that cash that was received 3 to 4 years ago, over a period of time, we've had to try to trace that cash through literally hundreds of iterative transactions. It's been traded, and give you chapter and verse within 4 working days. So we've done that as quickly as we can, and the information has now been provided. But that has involved a Herculean effort from the people within the business, but also from the lawyers. So not a lot of sleep has been had by anyone in the last 10 days. Now I accept we sign up for that, I suppose, but that is the result. That's genuinely the real result of the information order that was made. And as I say, we will need time, and you've given us time to assemble comprehensive evidence to respond to this application. And we do say this freezing order should never have been made, and they shouldn't have applied for it in the way that they did. But as you've noted, the primary issue at the moment is the. I'm sorry, I've just been told that somebody has entered the hearing under the name of Bob. I don't know who that is. Does Mr. Holloway know who that is?
I don't, I'm afraid.
It's from Lobsat. Low.
Can Mr. Bob please turn on his camera and identify himself, please?
Yes, I'm from Lobsat.
I don't know who that is.
That's the Loeb and Loeb. They are the claimant Hong Kong lawyers.
Right.
Sorry, will the gentleman who calls himself Bob give his full name, please?
Yu Chen Sang.
So would you spell that, please?
YUSHENSUN.
And we can't see you. Your camera was also...
Yes, sure.
Sorry, say again.
YUSHENSUN.
And you are from the Hong Kong lawyers representing the claimant. Is that correct?
Yes, I'm from Hong Kong lawyer. Yes, so
Representing the name of the party.
representing
Tell me the name of the party you. Sorry, tell me the name of the. Sorry?
Techteryx.
Techteryx.
Yes.
Okay. Any objections?
So as I understand this, I didn't catch any of that. So this is Mr. Who?
Yu Chen Sang.
Mr. Yu.
Mr.
Yes.
Justin's son, Mr. Yushen's son.
Yes, yes.
Are you Mr. Justin's son? Are you a lawyer?
Yu Chen Sang.
Are you a lawyer?
I'm not a lawyer. I'm a
No, he's not
client
a
of
lawyer.
Loeb. Yeah.
Sorry, you're not a lawyer. Who are you then?
I'm from Loeb. So I'm Loeb clients.
You're Loeb client.
I think this
So
might be
what
the
company
ultimate
do you
beneficial
what
owner
company
of
do you work
Techteryx.
for?
Techteryx.
He works for Techteryx.
Yes.
What's your position?
Advisor to Techteryx.
You don't work for Techteryx.
I work for Techteryx.
So you're employed by Techteryx.
Yes.
This is Mr. Justin's son. He's actually quite a well-known individual. He's suspected to be the ultimate beneficial owner of Techteryx, which has been part of what's caused the KYC problems. But he's not being straightforward about who he is. I didn't realise who that was. I'm being told that this is Mr. Justin's son.
Okay, this is all lost on me entirely. Look, I think, Mr. Yu, I'm going to ask you to leave this hearing.
Sure,
it's a private hearing. It will be transcribed. If you have access through your legal representatives, that's fine.
Sure, totally. No problem.
Okay, so I'm going to drop you out of the hearing,
No problem.
if I may. Okay.
Yeah.
Thank you, Your Honour. So just to frame that, you may have picked up that there have been problems with the redemptions in relation to this entity. And one of the issues in relation to that has been that it became known to FDT and then therefore to the fund that FDT was not investing on its own behalf. There was a beneficial owner behind it. And that's when Techteryx emerged on the scene. So the question
I mean, I found that an area where I'm going to need some assistance in due course.
Yes.
I've resisted the temptation to try and reconcile all the information. I'm sure those representing the applicant claimant have accountants who can reconcile the information you provided as to the investments and the redemptions. So I look forward to hearing much more about that in due course, but I realize today is...
No, I understand. But just to try and give you the headline, which is that there was a KYC problem once it was identified that FTT did not in fact own these funds on their own behalf. So when they subscribed, they ticked the box that said, we beneficially own these funds. And then Techteryx came along and said, no, we own the funds. And so then there had to be a KYC process in relation to that. So the question was asked, and I can show you the email in due course, who owns Techteryx? Is it Ms. Lee? And the answer never came back. And the suspicion is it was the man who was just on the call just now. And he is a distinct individual who is well known internationally and causes potentially KYC issues of their own. So that was part of the problem in terms of not being able to make the redemptions in cash.
Well, I hear what you say. Obviously, that's going to be the subject of further evidence and highly contentious.
Well, it's not contentious that the question was asked, and that's all that really matters.
Well, I've certainly seen the emails.
Very good. All right. So, Your Honour has to approach the question of the proprietary order on the basis of the American cyanamide case. So there are, in principle, three parts to that: the serious issue on the merits, the balance of convenience, and then the just inconvenience part of it. But as I say, you do have to consider the comparative strength of the claim as part of that, and whether or not the relief would be effective, and just picking out the relevant bits of the test, also the potential disruption to the business that could result. Those are specifically parts of the test that have been elucidated in the authorities.
So you're going to have to take this. I know that we're very, very familiar with this, but I would like to take down precisely the way you're putting it.
Yes.
So serious issue on the merits, balance of convenience.
And just inconvenient.
Yes.
And then when you look at how you apply the test, some of the elements that have been identified, and I'm just picking out the bits from my skeleton argument. So paragraph 71 of my skeleton deals with this. And so we've extracted an extract from civil fraud, and you will see there the various elements that are identified as being relevant to the test. And the first element is the comparative strength of the underlying claim. The stronger the claim, the less unjust the order is likely to be. Then the size of the claim, whether the relief sought will be effective, the potential disruption to the defendant's business, and the conduct of the claimant. So these are elements that you have to consider in deciding whether or not a proprietary order ought to be continued today. So you do have to look at that. Now, my learned friend told you at the last hearing that the reason for the original transfers that were made to my client had not been explained. He said that in his skeleton argument of paragraph 35.4. That is not correct. The claimant knew full well that the transfers were for the investment into the fund. They've seen the NAV and they've heard the explanation for the way in which those sums had been used. And I will show you this. They knew, because we had told them, that there are investments that had been made using those funds into trade finance, commodities, and various other businesses operated by the fund. But you had no submissions at the last hearing whatsoever directed at the impact the proprietary order might have on the fund or the entities within the group. Now, generally speaking, the courts will not make these sorts of orders where they will have a significant interference with a business. And I will show you that very briefly just by reference to two cases. The first, if you have it, is in the Respondents' Authorities bundle, and it's at page 240.
240, sorry, 240 of what?
You should have a bundle which has my client's authorities in them. We don't have control of the bundle, so the claimant's lawyers have controlled the way in which these things have been submitted, but there should be an authorities bundle.
Okay, I've downloaded. You don't have a page number in the full.
It's not in. I'm told it's not in the full bundle. There are two bundles.
Okay,
that's what we were told by my.
Let me see whether. I tried to avoid. Sorry, Mr. Holloway, what's that?
I don't think we were ever asked to put these in the bundle or even sent them, as far as I know. Refer to my learned friend skeleton, but I don't think we can be criticised for not putting them.
So I've got both. Let's not.
These were sent. These were filed. As I understood it, we've sent them to my learned friend solicitors.
Well,
it's an authority bundle.
Yeah, let me just try and find it rather than worry about who said what to whom. So I have both the online bundle and the download open. I can find documents by the page number in the download, or I guess the tab. What's the case called?
The cases are ArcelorMittal or
ArcelorMittal. Okay, I think I have seen. I've seen the reference to that in your skeleton.
It's tab 2. I'm sorry. It's not clear to me quite how this is supposed to be filed, but there we are.
So I've got return date documents, section J. Applicant skeleton, first respondent skeleton, exhibit, second witness statement. Not some authorities. No, I'm going to need help as to where it's going to, where I can find it. Fitzgerald.
I think you may have to come out of the main bundle, I'm being told. I don't have access to the actual bundle, unfortunately. This is all
okay, so I'm in the CMS. Sorry, case management system now. That's, which, as usual, has timed me out. Get back to that. Okay. Right, let me see what I've got. First respondents, legal authorities.
That's the one.
Go. Good. Right, cases, section 2. ArcelorMittal.
That's page 111.
Well, bear with me because the system is very slow. There, okay, page 111 of that bundle. Let's see if I can get to that.
So this is about this freezing order situation.
And that's
So,
a paragraph. Can you give me a paragraph?
240.
240. That's, I've got that. Okay.
Thank you. All right. And so what is said is,
Yep.
particularly in this type of context, the ordinary course of business exception is likely to create great uncertainty about whether particular transactions may or may not proceed without Anusa's or the court's consent. I agree with EGFL that, among other reasons, that gives rise to a risk that third parties will, for understandable reasons, refuse to accede to any transaction that has not been specifically sanctioned. It's well known that in practice, banks will not permit any payment to be made once a worldwide freezing order is imposed unless there is a court order or an agreement specifically sanctioning that payment. VTB is, in my view, correct in pointing out that, particularly in the present case, the scope for debate about what does and does not constitute the ordinary and proper course of business in the context of a freezing order with penal notice attached inherently undermines the ability of the group to go about its business with third parties. Every transaction of any size will carry the risk of a subsequent allegation of contempt of court or aiding and abetting a contempt of court unless prior consent is obtained. Having to seek prior consent either from a major competitor or from the court is bound to have a severe chilling effect on the carrying out of the group's business. It is therefore not unreasonable for Mr. Galcon of VTB to state VTB considers it a real prospect that a WFO would cripple the SR Group's business and cause loss to VTB. And then at the end, on page 121, that is one of the list of reasons why, in that case, I believe it was Mr. Justice Henshaw refused to continue the freezing order. And you'll see there, paragraph 267. For, in any event the order sought would be gravely detrimental to the business of the SR Group, a conglomerate headed by EGFL, comprising multiple operations across several countries with many employees, and noting 7, the freezing order sought against persons out of the jurisdiction in respect of assets outside the jurisdiction and in relation to matters with relatively limited links to England and Wales. It's appropriate for the court to proceed with particular caution in such cases. The other case in relation to this is the Polypec case, which you'll find, I'll just take you straight to the passage, which is at page 314 of the bundle. And you will see 784C.
Sorry, please bear with me. No, the system is a bit.
Just let me know, Your Honour, when you've got.
I'll let you know when the system's let me on.
Of course, of course.
You said 314.
314, please. Yes. There's the Court of Appeal.
I had it.
So it's at C on this page, 784C of the actual report. And it says, in summary, therefore, it comes to this. PPI has a claim against the central bank that, though a possible one, is at present based on little more than speculation. So that's an element of the assessment of the merits. A Morava injunction will inevitably seriously interfere with the central bank's normal course of business and will quite possibly destroy the central bank. If the Morava injunction is lifted, it is possible that a judgment obtained by PPI will be worthless. In my judgment, for two reasons, the balance comes down against the continuance of the Morava injunction. First, I regard PPI's present case against the central bank as no more than speculative. Second, it is, in my opinion, wrong in principle to grant a Morava injunction so as, before any liability has been established, to interfere with the normal course of business of the defendant. So it's wrong in principle to impose a Morava injunction that will have that effect in order to protect a cause of action that is no more than speculative is not simply wrong in principle, but positively unfair. And then there's the high degree of assurance point that I make. And I make that by reference to the Films Rover case. And if we can go to page 251, please, which is part of that decision. So part of that decision, page 251.
Yes, sorry again.
Whenever you're ready. Yeah. While you're waiting, can I just frame why it's important? So this
I've got it actually.
Oh, you do. Excellent. Page 251, and I'm looking at page 680, and this is the decision of Mr. Justice Hoffman, sort of celebrated rationalization of what had previously been understood to be a hard distinction between mandatory and prohibitory orders. And what he says is it's not a hard distinction. What matters is the harm. And so if we go down to G, you will see talking about the guideline. It's another way, this is 4 lines down, it's another way of saying that the features which justify describing an injunction as mandatory will usually also have the consequence of creating a greater risk of injustice if it is granted rather than withheld at the interlocutory stage, unless the court feels a high degree of assurance that the plaintiff would be able to establish his right at trial. I've taken the liberty of reformulating the proposition in this way in order to bring out 2 points. The first is to show that the semantic arguments over whether the injunction is formulated can properly be classified as mandatory or prohibitory are barren. The question of substance is whether the granting of the injunction would carry that higher risk of injustice, which is normally associated with the grant of a mandatory injunction. And then going on to deal with that. So the essential issue is not, is it prohibitory or is it mandatory? The essential issue is there a high risk of injustice if this turns out not to be justified? If there is, that is going to require a higher degree of assurance. So there are lots of factors to continue in this, and I don't propose to deal with them all, and we'll come back and talk to you about them for 2 or possibly 3 days. But the first point we make is that this claim is at best speculative. And there is currently no prospect, we say, of an order from Hong Kong being enforced in the DIFC anyway. So those are 2 slightly different points. One is about the substance, and one is about the enforcement of a judgment in the DIFC. And then the second point is that the harm which will result is very substantial indeed. And frankly, it is quite difficult to see what practical or legitimate benefit the claimant could get from a proprietary order, which they would not get from a freezing order subject to the business use exception in this case. And so we say when you look at those 2 elements, the choice for your honour will be very clear. So I'll start with the first point, which is looking at the merits. And I accept that we are doing this at remove, but Your Honour has to take a view on the merits, first of the substantive claim, and secondly of the consequence if a judgment is obtained in Hong Kong. And so again, I'll focus on what we see as the most significant points here, not all of it, because there's a lot. But just to frame it, for the claim to get off the ground, they have to establish a number of steps. The first thing that they have to establish is that they had a proprietary right to these funds in the first place. So in the hands of FDT, they say, well, we had a proprietary right, and they say they get that from the escrow agreement, and I'll show you that. The second thing they have to show is that the funds were misused, that there was a breach of trust, so that they were actually used in a way that was not authorized by them. The third thing that they have to show is then that Aria DMCC knew all about this, both that they had a proprietary right and that the funds were being used in a way that was unauthorized. Because if somebody steals money from me and uses it to buy a house, the vendor of the house does not hold those monies on constructive trust unless they know about the breach of trust, unless there's knowing receipt of money held in trust, or unless they dishonestly assist. So they have to show that at every stage. Now, the first stage of that, it appears to us, which is the question of whether they had a proprietary interest in the first place. The first stage of that appears to us to be very difficult for the claimant indeed. It says its proprietary interest is derived from an escrow agreement, and you were taken to some of the terms but extracted from the agreement itself. And my learned friend told you, I'll just remind you, and we're going to have to go back into the main bundle, I'm afraid, and I don't know whether that means it's going to slow things down. So page 1539.
Yep.
And there is an extract from the transcript of last time. And my learned friend says, you'll see, what is it? Three headings up from the bottom. Mr. Holloway, yes, he says, if this has to be construed in Hong Kong law, there may be arguments about it, but there are three clear places. He's talking about the escrow agreement. There are three clear places where they say they are acting as fiduciary, holding the funds for our account, acting as trustee. It says that in terms. So that's what you were told. The escrow agreement says in terms that the money was held in trust. And he refers subsequently, if you go over the page to 1540, you ask, where do I find that? And he says, it's recital, is it recital A or 3A? So he says one or the other. In fact, if you go to the document itself, it says nothing of the kind. If we go to page 502, you will see the escrow agreement itself. And I think what he's talking about in recital A is the first one. And you'll see there that's talking about a different agreement entirely. So what it says is the client and FDT entered into a client agreement dated 28 September 2020 and a custody agreement dated 28 September 2020, whereby FDT agreed to provide trustee, fiduciary, custody and other related services to the client. So what my learned friend said to you was that this recital tells you that the escrow agreement indicates that FDT were holding funds on trust for his client. In fact, this recital does use the word trust, but is talking about two other agreements. And it is not my learned friend's case that either of those agreements gives rise to the trust that he relies on. I mean, that's startling. The other paragraph that he referred to as clause 3A, which is page 503. And 3A says nothing about trust at all. And I'll ask you just to read that very quickly. But what it does say is fiduciary, an agent. But that's not a trustee. all fiduciaries are all trustees are fiduciaries. Not all fiduciaries are trustees.
Well, I took the view at the ex parte that this was a matter of Hong Kong law.
Well, it may be, but my learned friend has to show you a real case as to why there's a trust. And so, for example, if we go down to 505, so if you go over to page 505, and if your honor looks under the Roman numerals, you will see that there's a series in the Roman numerals 1 to 5. They explain a certain set of situations called triggering events. And then in the text below, it says, in the event of those triggering events, a resulting trust shall be deemed to arise. So where this agreement says there's a trust, it says it in terms. But the mere use of the term fiduciary duty does not create a trust. And my own friend's shown you no authority suggests that. I'm not aware of any authority that ever suggests that a fiduciary duty is the same thing and can only arise where there's a trust. And for what it's worth, if you go over the page on escrow amount on clause 6, if there was any doubt as to whether that might be the implication, it says that's not the implication, because it says FTT shall hold and manage the escrow account as fiduciary for the benefit of the client or its agents or designees. And then it says, for the avoidance of doubt, the client shall have no proprietary interest in the escrow amount. That's an overriding clause. So even if there was some ambiguity, that would override it, that would resolve it. We set simply unarguable. Because and if one steps back from it, what beneficial interest has FTT got to give? FTT is holding these funds, these sums, on trust for token holders, so that when the token holder comes back and says, I need to get those, I need that money back, they have to give it up. So FTT's no agreement between FTT and Techteryx could create a beneficial interest, because FTT hasn't got it in the first place to hand over. So that's the first stage. And then the second stage is very difficult as well, which is the authorization point. So it said that the payments were unauthorized, but actually my friend's case on this is inconsistent in Hong Kong. So if we go to page 813, this is the pleading in the case against Legacy, but also against the trust in Hong Kong. And if your honor looks at paragraph 44R, it's
sorry,
a bit of a
813.
Yes, please. Paragraph 44R. Mr. De Lorraine, you may have come across as the fifth defendant here. And what is said here is 44R. Prior to the closing date, the fourth and fifth defendant proposed, and so forth. And then if you see 5 lines up, is it 5, 6 lines up from the bottom, basically the middle of the paragraph, in light of the experience of the fifth defendant, and that's Mr. De Lorraine, the plaintiff agreed to this request, and the fifth defendant was appointed as authorized representative of the plaintiff, and all such actions were approved and ratified pursuant to a resolution of the plaintiff, and so forth. And
that's the board resolution. I remember that.
That's the board resolution, but sorry, I beg your pardon. I do apologise. We've been had to put this together a little bit at pace, so I'm sorry. This is my fault. Starting again. In addition to
as I understood the case, as I read it originally, if it helps, that somehow Mr. De Lorraine was one of the co-conspirators. Well, and that Techteryx were somehow persuaded to confer upon him authority that enabled him to siphon off the funds. That's what I understood the case to be.
Right. But just let's think that through. So here they're saying 44R. They say they appoint Mr. De Lorraine, and the point that I was going to show you was simply, sorry, it's in the first three lines. He was appointed as an authorized person of the plaintiff. So to run the business, to give instructions and directions to the operations. So you've got him being authorized to make those sorts of decisions. And then 44V, you've got him, and it says in terms that the fifth defendant authorized an aggregate of 456 million of the additional investment sums referred to in paragraph 25 above to be remitted directly to Aria Dmcc. So the pleading is that he authorized that.
Yes.
Now, it may be said, well, the circumstances in which he was giving that authorization were this, but actually their pleading is he was authorized to do it, and we're a third party to that. So this is an authorized payment, but they say it's not authorized. And they may say they've got claims against him or claims against other people as to why that authority shouldn't have been granted. But their positive pleading here is it was granted. And so therefore the transfer to DMCC was authorized. Now, you can't maintain a proprietary claim in relation to funds that you've authorized be invested into units in a fund. That what you get is a fund. You get a fund unit, but the money has gone if you've authorized it. So they claim
even if the authority is procured by fraud.
But
of course it'd have to be to your knowledge.
Yes, quite. So where's our knowledge in this? But they don't say that. They don't say that here. They say it was authorized. Now, in my learned friend's ex parte skeleton, he told you, and I'll show you that. If we go to page 1349, paragraph 75, he says, looking 3 lines down, the passages relied on in the parallel Hong Kong proceedings have been selectively quoted. In fact, A pleaded that Mr. de Lorraine purportedly authorized the additional investment sums in breach of fiduciary duty, and that they were made without the knowledge, approval, or authorization of A. He gives no reference to that, but I've just shown you that's not what they say. They don't say they were purportedly authorized. They say in Hong Kong he authorized them. He was our authorized representative. He authorized the payments. Now, the effect of that, if it was induced by what? Fraud. I can see if the whole thing is a sham, that's one thing. But their positive case in Hong Kong is that he was authorized to do this, and he did authorize the payments. And you were told something different in the skeleton argument. So in the other claim, the one against FTT, so this is the separate set of proceedings, it is pleaded that the payments were unauthorized, and you see that at page 715. And we have to look at why that is. So if you go to 715 and you see paragraph 66, they say the 6 remittances were blatant misappropriation and money laundering, and say various things. And subparagraph 2 there, they say they were made without the knowledge, authorization, or approval of the plaintiff. So the first point there is that's flatly inconsistent.
Sorry, let me catch up. So this document is the pleading against
FTT. This is the FTT proceedings.
Yeah. So
you've got the legacy proceedings and the FTT proceedings.
Para 66.
So 66.2.
Yeah.
He says the payments were made without the knowledge, authorization, or approval of the plaintiff.
Yes.
And then
so
says,
that's inconsistent with the fact that Mr. de Lorraine approved it.
And was the approved representative.
Yes, sorry, Mr. de Lorraine was the approved representative.
So this is all, and we don't expect you to take a decision on this.
No, I'm not going to.
But what we do ask you to do is note that this is shifting sand from that. So this is all a new case that was introduced subsequently, as you can see from the markup.
No, I understand the context of what you're saying. You're saying this is in the context of the test that I have to apply for continuing the proprietary injunction.
Yes, correct.
Yes. Yeah, I have the context.
And I'm showing you that they're saying two inconsistent things in relation to this, and it doesn't stack up. And then what they do is they say, paragraph 67, the fund was a fraud. And I'm going to deal with that separately, the sort of fund is a fraud allegation. And then paragraph 72, well, there's a bare pleading on the following page at paragraph 70, which just says, well, all the other defendants must have known and in fact did know that the fund was a fraud. But that seems to be based on the allegation the fund is a fraud. And you can sort of understand that in a way. I mean, if the fund is just a sham, then, you know, if Mr. Britain is just not doing anything with this money other than siphoning it off to Panama, then obviously, you know, one way or another, you can sort of see that. But that's not a particularized allegation. And what else beyond that is there? Paragraph 72 deals with this, with the knowledge. And what that says is that everybody acted together in the fraud to injure the plaintiff. And then they says, including the fund, not DMCC here, but nevertheless, I'm not taking a technical distinction between the two. Their involvement, knowledge, and intention can be inferred from the matters as follows. Now, if you're pleading fraud by inference, you have to set out the matters on which you rely. And if the facts are consistent with a non-fraudulent explanation, then that is going to fail. But here, what's important is to look at what is actually said against the fund. And the answer is really nothing. What you've got is essentially, the fund is hardly even referred to. The first three have nothing to do with the fund. And then 4 is, it defied common and commercial sense to invest in the fund. It's just pure assertion. Why does it defy common and commercial sense from the fund's perspective to have these monies invested? And then you've got...
Well, I mean, it seems to me pretty obvious that to invest the underlying funds backing a stable coin in illiquid investments does defy common and commercial sense.
But it's not suggested that the claimant was aware. Sorry, the first respondent was aware.
No. I mean, that may be at a much higher level than the investment itself. Yes,
it may or may not. And these were supposed to be income generating investments. I mean, I'm not in a position to give you chapter and verse about what was supposed to be done with the assets that were backing the stablecoin. But as I understand it, it was permitted to use them for certain purposes. But I'm not going to get into that because I don't know. The question that I'm asking you to look at the moment is, what is the case against my client as to what it knew? As an investment manager, it's being offered funds from FTT, which FTT is saying, these are my funds, invest them. This isn't an allegation that's being made against my client, as far as I can see. Really, all you get, the best you get, is at 9, really, which says the way in which Truecoin FTT, Finaport, the fund, Mr. De Lorraine, Mr. Chock, Mr. Ye, Mr. Britain, caused and documented the purported transaction of the additional investment sums and the 6 remittances, including the lack of basic due diligence and anti-money laundering checks, shows the same. That is it. So what you've got is a totally unparticularized allegation that the way in which it was documented is somehow indicative of fraud. And the second bit, which seems to be about anti-money laundering checks that FTT undertook. And then the only other references that you've really got is if you go to 18 it's 2 pages on page 665, you've got the allegation that when it all fell apart, the fund, FDT and various other people continued to side with the fund and Mr. Britain. and did not look out for the plaintiff's interests. I mean, this is the sort of pleading that you're dealing with here. And then 19, when and after the fund, Mr. Britton revealed or claimed that the fund's assets had been invested in the way detailed, Mr. Chock and so forth did not express any surprise or disappointment.
But I mean, what one did have on the ex parte were investments in end-dated 3-year bonds, which were not redeemed. Now, there may be an explanation why the redemptions were not permitted, but both the coupon and the bonds upon their or investments upon their expiry were not paid. I mean, that's what I was faced with on the ex parte, and that's what I'm going to have to be addressed on the merits when we come to take everything apart, as it were.
You weren't shown the evidence in relation to any of this. So the coupons, for example, were not guaranteed coupons. There was no default in relation to the failure to pay coupons. There were some redemptions that were made, and some coupons were paid.
Yes, some.
But the fact that a fund doesn't pay out redemptions when they're anticipated is not indicative of fraud. It's an inferential case. You have to take the elements on which that inference is built, and ask yourself the question: does that inevitably lead you to the conclusion that this is fraudulent?
Well, I mean, yes. I mean, I accept that, and these are questions for another day, because we're dealing with matters as we accept at a very preliminary level, but even more preliminary level on the ex parte. What was presented to me was that these, at the very least, are ill-advised investments, and my preliminary view is that must be right. To invest in illiquid funds when you're backing stable coins. And then, lo and behold, they were not paid into the fund. They were paid to a third party, your client. And then, lo and behold, when they attempted to redeem, they weren't redeemed, and they were not paid the coupon that they were promised. So that was the basis of the grant of the injunction.
That's not actually the reasons that were given for the ex parte, and they're not the pleaded allegations on which the inference is built, which is what I'm trying to deal with. And this is the problem. We answer the case, and somebody comes up with another reason. But actually, there is an explanation for the way that the payments were made. And my reading of the ex parte transcript was that Your Honour wasn't particularly interested in that aspect of it. There were other aspects of it that you had more concern about, like the share register, which I can show you today, by the way.
Yes, well, that was that. Yes, I was certainly concerned about that on the material before me.
Yes, but what have you got? I mean, you've got so the way it worked, as I understand it, was that the original investment was going to be made into Dmcc. And that was ultimately ported back into the fund. And that's why you ended up with retrospective board resolutions and that sort of thing. Now, Your Honour was concerned about the board resolutions and seemed to be doubting whether they were binding or not. But that was never in dispute. That board resolution was a binding board resolution.
The 8th of March board resolution.
Yes, it was never disputed.
I thought the case was that was that there was that was procured as part of the fraud.
There's no allegation against my client in relation to that.
No.
So what my learned friend told you, and I'll show you this, it's a paragraph 76 of his skeleton argument for the last time.
Yes.
That was me. So what he told you. Sorry, paragraph 75, and it's the last sentence. He says, insofar as A purportedly accepted First Digital Trust and Mr. Lorraine's purported investment of the additional investment sums in the fund, this was induced by fraudulent misrepresentations, including by Truecoin and Mr. de Lorraine. So even he makes no allegations against my client. But actually, his reference, do you see there, is to Ms. Lee, paragraph 69J to L. You can find that on page 39 of the bundle.
Okay, what are we looking at on 39?
We're looking at the passage that my learned friend referred to in paragraph 75 as supporting his case that they were induced, that the board resolution was induced by fraudulent misrepresentations. And you see J to L. And if you read those passages, you'll see it says nothing of the sort. But even if it was, there's no allegation against my client. My client induced it by fraud. So if you're asking the question, as this money passes, is there a problem within FDT or Mr. de Lorraine about what he did, what they did in extracting the money and paying it out? But then my client needs to know about all of this. So my client needs to know that Techteryx has some difficult to understand proprietary interest in this sum. My client has to know that it's being handed this money in breach of trust. And all of these allegations that are made, and those stages they say, and here is how we say that the fund or DMCC knew about this. There's no case on that. So what they do is they just mix up all the defendants together and they throw a lot of allegations at everybody, but they never really explain what is their case as to why that is impressed with a trust, even if it was impressed with the trust as it left. What is their case as to why it's impressed with the trust when it was received? Now, and that's why we'd understood Your Honour was focused in on this question of whether the fund was a sham. That the fund is a fraud is the allegation that's being made. And of course, if the fund is a fraud, what one can see that the court might not be so worried about sort of dotting the T's and so forth in relation to authority, because they will say, well, look, if you're receiving anyone's money and you're not doing with it, you're not actually investing it, you're just sending it off to Panama, then that's a different thing. I can see that. But the claim that the fraud is a fund, the fund is a fraud, sorry, is a very extreme case indeed, if one thinks about it. And it's completely contradictory to the claimant's own public statements, for example. So if you take, for example, the holdings report, I'll just show you, this was 4 days ago. It's at page 2393, so I think it's right. That's in my bundle anyway. Page 2393. You've got the true USD holdings report.
Sorry, I think what is that exhibited to?
This is exhibited to Mr. Britton's
second affidavit.
Second affidavit, correct. Thank you.
Yeah, in which case, I don't have that in my downloaded bundle, so let me just go to the loose copy.
Oh, sorry, no, that is his first affidavit. I'm so sorry, I'm told. It may be right at the end of your downloaded bundle.
23. I've got two. My download bundle goes to 2349.
Oh, I see.
But I've got the exhibit.
2349 is halfway through the exhibit.
Oh, okay. Yes, I had a problem with the download. I have. Okay, then I know what the problem is.
I see.
What the problem is. Let's try again. No. So I'll have to go to the the online bundle, which may be a bit slow in that case. Forgive me. And it's timed me out. Yeah. Two, three, nine, three, two, three, three. Sorry, just waiting for the bundle to load.
Understood.
Maybe I can find a quicker way. So I do apologize.
No, don't. I fully I'm aware of the circumstances. It's a shame we can't break the bundles up into smaller pieces and have multiple bundle instances running at the same time.
Yeah. Well, I should be having words. Is MBW2?
Yeah, which is the exhibit to the, sorry, yes, it is the exhibit to the first affidavit, I think.
Maybe I can find a different way. I maybe get it actually from the filed copy, which is from this morning, quicker. MBW3. It's MBW3, isn't it? Is it from this morning's filing?
No, this is from the one that came in, that went in previously. So this
okay, so that's 14th. That's 14th, isn't it? March. Let's have a look.
It's attached to Mr. Britton's
MBW2 there. I've got it from the original filing. Might load more quickly.
It's 533 of that exhibit.
Yep.
Yeah, I'm just trying to load this now.
It's the second last page of that exhibit.
Okay, second to the last page of that. So what is the actual MBW2 / number?
533.
533.
MWB2/533.
Well, that's brilliant because this ends at 341. Why is that? Oh, it's in there. It's downloaded in multiple parts, that's why. So that's the last part. Right. Ah, at last, 533. I have it. Good. Okay.
So this is the true USD holdings report, and you'll see top left Techteryx DBA as true USD, and you'll see there in the list of holdings it says USD denominated collateral, and then under the second line First Digital Trust Limited. So this is a public statement, and if you go back, if you can, 2 pages, you'll see that these are audited statements made to the public about the collateral holdings. So this is what they're telling the public, and they're telling the public that they've got holdings through First Digital Trust. And if you look at the notes, note 2, 4 lines down at the end, you'll see reference to the Hong Kong Depository Institution. You see that has invested all or substantially all of the collateral in other instruments to generate yield, which are made up of investments that cannot be readily convertible to cash, subject to market conditions or fund performance. So they're telling the public they've invested these sums, or FDT has invested these sums. And if you go further down, what they say is that Techteryx has instituted proceedings against the Hong Kong Depository Institution, namely First Digital Trust, FDT, to accelerate redemptions and recovery of all of the amounts invested. So what they're telling the public is that they have invested and they are redeeming. So they're not saying it turned out that we got scammed out of this money and we're trying to get it back. They're saying we are invested. And then there's also this issue, because part of what they told you last time was, well, we can't be sure that we've actually become shareholders in this fund because we've got no shares issued. But if you go to page 1421, I'm sorry we're jumping the bundle around.
That's right.
I just wanted to show you what Mr. Britton pointed out about the Cayman proceedings. This is the easiest way to do it. You can find it in Ms. Lee's affirmation in the Cayman proceedings. But essentially what happened was Techteryx brought proceedings in Cayman saying we're entitled to information about the fund because we're a shareholder in the fund. And so here Mr. Britton was reciting some of the things that Ms. Lee said in those proceedings. And I won't take you to the whole lot of it, but if you see at paragraph 1 to 4, and the conclusion there, Ms. Lee, who is the same Ms. Lee as who gives evidence in support of the claimant's case in these proceedings, says there is no doubt that FDT is the registered shareholder of significantly more than 20% of the shares in the fund, and therefore holds the requisite amount for standing to bring an inspectorship application. So she's telling the Cayman court that Techteryx is a shareholder, but she's telling you that the fund is a sham and there are no shares. This was the subject of her very recent evidence that came in on Friday. Yeah. I don't know whether Your Honour seen that, but the
second affirmation, is that right? Yes.
1674 in the bundle. She deals with this. And we consider that her response on this is absolutely astonishing. Paragraph 14, if you have that, she refers to it. And she notes that it's suggested in Hong Kong that it's an abusive process for Techteryx to take the opposite position in Hong Kong. And then she says this is her complete response to it. This overlooks that First Digital Trust needed to assert a shareholding qualification to bring the proceedings under Cayman law. She says it was settled before it was determined. Even that is, as I understand it, false. Once they gave a non-disclosure application, we shared the information. But this overlooks that First Digital Trust needed to assert a shareholding qualification. So what her position is that she said it in Cayman because she needed to say it in Cayman, not because it was true. The point being that Techteryx needed to establish that there were shares in order to support the application. So she's been caught out saying 2 contradictory things about this in 2 different fora, now 3 different fora. And her sole response is, oh, well, I had to say that, otherwise I wouldn't have got the application off the ground. I mean, that's what you're dealing with, Your Honour. And the other thing that she says in this application, and what you were told at the last hearing, was that there were no audited accounts for this fund. And in fact, there were. And again, I mean, this is simply brushed off. My learned friend brushes this off. So you'll see where she says that in the bundle. It's page 34. And it's paragraph 67A. There are no audited financial statements. She says that in terms and swears to that in this court. My learned friend picked that up in his skeleton argument. And that was simply untrue. And just pause there and think about the impact of that. Mazars, an international accounting firm, has gone through the financial information of the fund and has signed off on these accounts as being a true and accurate representation of the financial activity of this group. And when you're asserting that the fund is a fraud at the same time, that is pretty material stuff. Mazars are confident that this is a real functioning, effective fund. So if we go to those accounts, they're at page 1770. And I won't take you through them in huge detail, but you're on a walk to read those. And if you go to page 1773, you will see their opinion, and you will see they confirm that they've undertaken a full audit in accordance with the IFRS standards. So it's the International Financial Reporting Standards. And your Honour will know that that does not just involve relying on management information. They have to come in and they have to apply professional skepticism and specifically look out for fraud. So Mazars have gone on record and dealt with this. And my learned friend says, oh, well, somehow, one way or another, you can put this together. This is still not a functioning entity. This is not a real fund. The way my learned friend tries to deal with this is in paragraph 11 of his most recent skeleton argument. And he says, well, unfortunately, this is a bit unfortunate, it's a bit regrettable, and we didn't tell you the right thing about this. There were, in fact, audited financial statements. And what he says is, oh, but they were late. This is paragraph 11. And he says, this is the middle of his paragraph 11, they were accounts prepared for management purposes only. So he says you can't rely on them. Ms. Lee picks that up in her affidavit as well. That was a new complaint now. So the complaint shifts. You're told there are no audited accounts. So you make this order. Friday, Ms. Lee comes back and says, oh, well, actually, there were audited accounts, but they were only for management purposes. And so now we have to scramble to give you an explanation for this particular point, which we have managed to do. If the complaint is about, if you're in the accounts, Your Honour, I'll show you the position. It's 1774. And you'll see there at the bottom of the page, it says these financial statements have been prepared solely for the internal use and management and are not intended for filing with any governmental or regulatory authorities within the Cayman Islands or outside. So that's what my learned friend picks up on and what Ms. Lee picks up on. And so if you go down now in the bundle, and I'm afraid you're probably going to be into you're in M.
Sorry, just going back to 1774. Where
oh, I'm sorry.
Is that passage?
It's at the bottom. It's sort of 2/3 of the way down the A4 page under the heading restriction.
Restriction. I've got it. Yeah.
Correct. And so my learned friend picks up on that, and Ms. Lee picks up on that and says, oh, well, you can't rely on these accounts because they're only for management purposes. They're not to be filed. And so we've scrambled to get an answer to that question. And the answer to that question comes from Mazars itself. And if you go to exhibit MWB 3, page 83. Well, I don't know whether you have it in the bundle. If you have it in the bundle, I can give you a bundle reference, but otherwise it's page 83 of the exhibit.
Let me see where I can best find it.
I understand. If you've got access to the full online bundle, you could set that going at least. But it would be the place to start would be 2486.
Yes, I'm there, but it's just not loading for me.
Yeah, I understand.
So let me. I think it's probably easier for me to find it actually from the filing. So that was filed on the 14th, wasn't it?
I think that's right.
Stafford Davis. Sorry, we're
MW3. And if we start at page...
Sorry, that's filed on the 17th, not the 14th. Okay.
Oh, I'm so sorry. You're absolutely right. Sorry. I
no, that's okay. I've now got it. So it's just
very grateful. So it's page 82 of the PDF. Sorry, page 82 of the exhibit. And
yeah.
in the
wait a minute. '82. Yep, I have it.
Now, the reason I take you to 82 is because in the middle of the page, what you see is a response from Mazars to a previous email that has come through to them. And what in the middle of the page, you'll see Mazars saying, "Thanks for the below. Please see my responses in blue." So then we go look at the email below and we see what they're saying about it. And page 83 at the top, talking about this restriction, it says for number 2 below, I haven't seen a Cayman audit firm use Bannerman language recently on my fund clients in their audit opinion, but we're fine with it. We're informing you now that we obviously have to share and file the financials with CIMA, which is the Cayman regulator, and the financials will be shared with investors. And the response comes back from Mazars. We're aware that the financials are shared with CIMA and the investors, etc. It's used by firms to limit liability from other parties in the unlikely event of a dispute based on parties other than the directors having placed reliance on the financial statements. How much weight it carries in practice, I couldn't tell, but firms are strongly advised by legal counsel in Cayman to adopt the wording in audit reports. It's derived from UK law and also strongly recommended by the ICAEW, so that's the English and Welsh auditors group. The only institution who does not accept audit reports with that wording is the SEC. So for PCAOB audits, we are required to remove that paragraph. I've not come across an audit report of any Cayman firm who did not have some form or a variation of that wording with very minor differences, if any, unless, as mentioned, PCAOB audits or other instances where the financials are required to be filed with the SEC. The inclusion of the paragraph will not impact the CIMA filing, and CIMA does not object to that paragraph. So what's happened is you've been told there are no accounts, and then they've said, oh, well, actually, there are accounts. And then they said, but you can't rely on them because they've got this language in them saying they can't be used for regulatory purposes. And then we've run around and find the reason why that's in there. And the answer is it's in all of them. So my learned friend is now making points which I've absolutely no foundation in reality to support a case in fraud, that this is a fraud. There are some other forensic points that are made by Miss Lee. Some of them Mr. Britton has been able to pick up on. And they are really reaching. I mean, she says, for example, well, the accounts say that the fund was established in 2007. And Mr. Britton makes the point that that's a typo, and it should say under the Companies Act 2007, not that it was established in 2007. I won't go through all of these little bits and pieces.
No, I mean, in terms of timing.
Yeah, well, there's a bit more, I'm afraid, and unfortunately, that's just where we are. But the point is, you've now got audited accounts from Mazars saying this is a real business which does what it says it does. Mr. Britton has provided such information as we've been able to gather over the past few days, and I trust you've been able to read that, Mr. Britton's first affidavit.
Yes, I've read the affidavit.
I'm grateful. So just to remind you, if we go to 1844. I won't take you through all of this, but from 15 onwards, he describes the nature of the business, and 18 onwards, he gives, paragraph 18, he gives some examples, and it's starting on page 1845, of the sorts of operation that there are. And these include real functioning facilities, a bitumen production facility, refinery, distillation plant, an extrusion plant, terminal storage, and then there's 2 mining concessions in Tanzania. There's a waste lead battery plant.
Yeah, you can take it. You can take it that
I'm grateful.
Got this on board.
All right, but this is supported also by documentary evidence. And again, I'm not going to take you through all of that documentary evidence, but what you've got are subscription forms for the fund. You've got subscription confirmations. You've got NAV statements, investor listings, redemption requests. You've seen the auditor reports. And
yes, I've been through those. I resist the temptation to try and analyze them myself. I'm sure the other side will have Kroll look at them in due course.
I understand that, but there are even various contracts there, for example, showing that the fund's extending finance, and there's documents showing the operations in relation to the bitumen facility. There's payroll information for that facility.
I accept entirely on the evidence that there are underlying businesses.
Right.
That impacts upon one way in which the case is put against you.
Well, what are the other ways? The way that it was, the fundamental way that it has to work and can only work is if the fund is a fraud.
Well, it depends what we mean by the fund is a fraud, whether the whole fund is a sham, or whether it's taking money to which it is not entitled and investing it in its own businesses.
Taking money to which it's not entitled.
Yes, so in other words, the funds that, I mean, it's not for me to make that case for them, but funds, let us say, I mean, you say knowing receipt, or the funds are impressed with the proprietary interest by the claimants. But there is a case other, it seems to me, than the fund merely having no business at all.
Well, but what is it? I've shown you what's pleaded. I've shown you what's pleaded. So what is that case? The way it was put to you was the fund is a fraud. The fund is a sham. That was, and every time you were on ask the question, well, hang on, what about this? What about that? It would retreat to that. The fund is a sham. So we've gone to great lengths to show you that the fund is not a sham. It's a real operating fund. And now the proposition's put, well, what about the case if it's not a sham? And if this money was just not supposed to go and be invested in this way? Well, then my learned friend has to have a case about how we knew that all of these things happened in a way that was wrong and shouldn't have happened, even if you can make that out.
I see.
And what's the case on that? What is the case? There is no case. There's no case, for example, that here's a document that shows that you were told that this was all unauthorized. And there's no case. And I've shown you the inferential case about as to knowledge. That's what's pleaded in Hong Kong. So, okay, there's no direct evidence that you knew this, but here are the facts that we rely on. pursuant to which you have to infer that Aria, DMCC and the fund were aware that this money was being misused. What is it? There isn't anything. There's nothing there against my client. No, don't interrupt, please. And that is beyond the point where they have to show that they've got a proprietary interest in these monies in the first place, and that we knew that. And it's speculative in the extreme, put on the basis that this fund, and that's why there was a constant retreat to, well, the funders are fraud. The funders are fraud. In the sense that it's a sham. That's how it was understood. Now, Your Honour was worried about the share register. We now have the share register. I don't know if you've seen that yet.
I have looked at that. I think it needs a bit of explanation.
Well, let's do that now then. So paragraph, bear with me. That's Britain 2. It's the exhibit NWB3, page 1. So we were just in that exhibit, and it was
Let me find
at the end of it. So my own friend's case was, well, there's no share register. What he didn't do was say, look, these are the features of a Cayman mutual fund share register. This is what a share register has to have. There's no document that matches that description. So we've had to do that job for you. So what we've got is on page 1 is the share register, and page 2 is the Cayman law on what it's the new law, 2025 law, about what has to be in a share register. So what you've got is, let's start with the law, which is section 40, which is on page 2 of the exhibit.
Yes.
And just to be clear, it's a mutual fund. So what happens is that head office holds the voting share register, but the fund administrator holds the participating share register. That's not us. There's an independent fund administrator who deals with that. What does it have to have in it? You'll see Article 4, Section 40. It's got to have the names and addresses of the members, and then it's got to distinguish each share by number if there's a number. Right? My understanding is there isn't. There isn't in the register, and so I take it from that. Confirm the amount paid or agreed to be considered as paid on the shares. Confirm the number and category of shares held by each member. Confirm whether each relevant category of shares carries voting rights, and so forth. And then the date, B is the date that they were entered on the register, and also the date if they left it. So that's all. There's no specific form. It just has to be a register that is held. If you go back a page, you'll see that's what that does.
So the only shareholders in the fund are First Digital Legacy.
No. These are the shares. These are the Class C USD 3-year 6 shares. So
sorry, looking at a register of its members. So this is not a register of the members of the company. This is a list of the investments that are said to be held by First Digital Legacy. This
is a register of
well, let's look
at
the register. Every company shall cause to be kept in writing a register of its members.
Yes.
So this is not a register of the members of the company.
This is an extract from the register, as I understand it.
So it's an extract from the register.
Yes.
So it's not the register.
Yes. Well, it's part of the register. So Your Honour said at the ex parte, what we should be doing is producing a redacted version of the register. So
yes,
in other words,
see the original. I'd like to see the original register, and they can redact the names of other people. But so we haven't got the register. We've got an extract which has been created for the purpose of these proceedings on the 14th of March.
But a register is held digitally. I mean, a register is not a physical piece of paper, so of course it's got to be printed out. We're showing you the register as it is today. We can in the time that's been available, that's all we can do. But we'll get you any other documents you want. But this is the register produced by. Can you see? This is the independent fund administrator producing the relevant extract from the register for this particular individual. These investors.
So this is an extract from the register.
this is as well. You can see it lists the Class C shares USD3 6%. Identifies the type of shares.
Yes. What happened to the
So
Class
would you like to
Ds?
see the register for the rest of the shares for the
Oh,
fund? Is that the problem?
when the Class D shares held as well? I thought the original 97 million was invested in Class D as well as Class C.
I don't know the answer to that. I can check that.
Yeah.
Someone will tell me the answer to that.
Okay.
Sorry, I'm being told to take you to the PPM, but I don't know which bit of the PPM, so hopefully someone will help me with that. But the private, so the PPM requires, I think the point is that the PPM requires the administrator of the fund to hold the share register of the participating shares.
Yeah.
So what we've done is we've gone to the administrator of the fund and we've said, send us the up-to-date share register relevant to these people, these parties, and this is what they've sent us. And as far as we can tell, that is consistent with the obligations under Section 40 of the Cayman Companies Act. And the PPM says, I'm told, I can show you, I'm sure if someone gives me a page number, that this is definitive evidence of the shareholder. I'm just struggling with what more Your Honour wants from us in relation to this. If you want to see the shareholdings of other investors in the fund, we can produce that too if that's what you want. We'd understood that you wanted to see an extract from the register which showed the shareholdings of First Digital and Legacy, and that's what this does, as I understand it. But we can produce those other documents if you want us to. I mean, what we don't want to do is produce something and then have somebody say, oh, well, hang on, there might be some problem with that. It would be much better if we understand actually what we're being asked to do.
Yes, I assumed that whether it's physical or whether it's digital, there would be a register. There would be entries on that register in relation to First Digital. Surprisingly, Legacy is still there. And that they will be amongst other entries for other shareholders. The identity of those shareholders could be redacted, but at least I was hoping to see a comprehensive register amongst which First Digital figured, which is why I mentioned, and the reason I mentioned redaction is obviously I did not wish to know the names and addresses or see published the names and addresses of other members of the company.
Right. So as I understand it, this is a complete register of these sorts of shares in the participating shares in the.
I don't know. I don't know about.
Well, that's what I'm telling you. My understanding is that's what it is. Of these sorts of shares, I understand there are some other investors in the fund. I believe that's the case. I don't have evidence of that before you, but we'd understood you wanted to see the register in relation to, or there were. I don't. Sorry, that's oblique. Right, maybe that's it. Oh, I see. Sorry, I'm just getting confirmation. This perhaps is the answer. That there were other investors and there aren't anymore. So these are all of the funds in the fund. So I apologise. Might have helped me to clarify that earlier.
So
I believe that's it. Is that right?
Only First Digital and Legacy are investors in the fund now. Is that?
I'm hesitant to give you evidence on the fly, Your Honour, because we've not been here. I'm just waiting for my instructing solicitors to tell me precisely the answer that they're confident in, and I will transmit that to you. But I've certainly been sitting with this for 7 days, so I don't have every single piece of information.
No, of course not. I'm very much in the dark.
Right. The answer is yes. The answer is that there are no other investors in the fund anymore, and so it's Legacy and FTT, and that is it. So this is, as I understand it, the complete share register.
And just to make it absolutely clear, no other investors in the fund at all, or no other investors in Class C?
No other investors anymore
Okay.
at the moment, full stop. So there have been others and they've, I think, been redeemed, is what I'm being told. But again, I don't have chapter and verse on this, and we'll need to come back to it.
No. Well, we're not even dealing with the injunction application fully today. We're only dealing with variation anyway.
Yes. So the difficulty, as I said, with redemption in relation to, so sorry, just to clarify on this, then you may have seen Mr. Britton, what he said. Your Honour was caught by his evidence a bit in Hong Kong in relation to the share register, and he mistakenly thought that when Ms. Lee had referred to the voting register, that was the relevant share register, and he's explained that in his evidence. I don't know whether you've seen that.
Yes, I've seen it.
It's a genuine mistake. I mean, unless my learned friend is going to sit there and say that this document is somehow manufactured by an independent fund administrator, then you can rely on it. And if you can't rely on that, then what can you rely on? I mean, where are we? Where does this end? And then the other thing I think that you were worried about was Mr. Britton's evidence about the jurisdiction agreement in the subscription form.
Well, I think that may have just been counsel trying to be clever.
Well, I think that's probably right, and it's unfortunate. But he's given an explanation of that, and so to the and there we are. It is what it is, but it's not, doesn't take you to this as a fraudulent enterprise. In relation to redemptions, the point very briefly is that when the subscriptions were made, and I can show you an example of this. If you go to page 1861, you see a subscription application form. And if you go to the second page, 1862, you see there's a question and there's a box to tick at 6. It's a bit difficult to see, I'm afraid. And you can either tick a box saying if the subscriber is the beneficial owner, or you can tick a box that says if the subscriber is subscribing for on behalf of customers. And the box that's ticked is the subscriber is the beneficial owner. So now when Techteryx came and said, no, these are our funds in some way, the question became, for KYC purposes, who owns Techteryx? And so on page 1945, that question is raised and referred to Techteryx. You've got an email exchange there. And they say, we need to know who the ultimate beneficial owner of Techteryx is now, if you're saying that Techteryx is the owner of some of this or has some proprietary interest in this. And the answer comes back from FDT, we've reached out to Techteryx and we'll tell you, and we've had nothing since. So the result is that there have been significant KYC issues. One, in part, the resolution for that has been to try to deal with this by way of securitization and to redeem by handing over notes, and that is a process that is ongoing.
Yes, I mean, I can see some issues with that. Obviously, it depends on whether the bonds are regarded as investment grade, whether there's a market for them.
Well, I think the point is that we can redeem in kind under the terms of the PPN. We don't have to hand over cash.
Yes.
And so redeeming in kind, as I understand it, avoids some of the problems that are associated with trying to give cash back when people like Mr. Justice Sun are involved. So this is one of the ways around that particular aspect of it. And the point is that we can then hand those notes over to the investors and they are redeemed. And that is permitted by the PPM. So that, and then they can receive the income in relation to that, and if they want to, and if they're able to trade in those notes, then they can do so too.
That's not a problem for me, I think, at all.
No,
certainly not for today.
No, perhaps not, but save that they knew all about it. they knew all about this, that this was ongoing. And so they pleaded it. They pleaded it at page 711. You'll see the pleading in Hong Kong. And it actually pleads at E, the fund has commenced a securitization process.
Sorry, paragraph.
It's a little e. It's part of 63, so 63.2e.
63 2 E. That's 713. I have it. Yeah.
I'm so sorry, it's 713. You're absolutely right. The reason, I'm afraid it's difficult to read that.
Yeah, of course.
So they plead, the fund has commenced a securitization process, which once completed will see the majority of the fund's receivables and inventory currently appearing on its balance sheet replaced by a number of commodity asset-backed traceable notes representing the coal mining tenements in Tanzania. In fact, it's everything. It is the plan. So they were aware of it. They were aware that this process was going on. And the reason they were aware of it was because they were aware that that was the process by which there would be redemption. I'm not going to, so the two further points on the merits I just want to make very quickly, if I may.
Okay.
The first goes to the enforceability of a Hong Kong judgment. Now, Your Honour was given the wrong test for enforcement at the last hearing. So page 1554 is the transcript. My learned friend accepted there that he had to show you a real prospect that the judgment would be enforceable here. That's in the middle of the page. And then he says, well, it might be said.
Sorry, can you just give me that page number again, please?
1554.
1554. Thank you.
So my learned friend in the middle of the page, he says, we also have to show a serious issue that a judgment would be enforceable here. I guess one of the defences that could be raised is that the Hong Kong courts themselves do not have jurisdiction over Aria and Dmcc. And so then what he says is, if you look a little bit further down, he says, there is a pretty clear anchor defendant in Hong Kong. And then you say, well, we're interested in Aria Dmcc. And then over the page, he says, 3 down. But if the case will proceed against FTT and the money has gone through Aria Dmcc, it would seem clear they are necessary and proper party in those proceedings. So that's the way the case was put. And you said, I suppose I can assume that Hong Kong has the same rules as England. But that's the wrong test. That's about whether the Hong Kong court would take jurisdiction under its own rules. The test on enforcement is not that. The test on enforcement is the common law test for enforcement. And actually the answer it was buried in my learned friend's exhibits. If we go to the memorandum of guidance, which of course itself is not binding, but DNB says that's how we do things. If you go to page 1316, just summarizes the test. Para 6.4, the Hong Kong High Court must have had jurisdiction according to the rules of conflict of laws applied by the DEC courts to determine the subject matter of the dispute. The DEC courts will generally consider the Hong Kong High Court to have had the required jurisdiction only where the person against whom the judgment was given, A, was at the time the proceedings were commenced present in the jurisdiction of the Hong Kong High Court, B, was the claimant or counterclaimant, and C, submitted to the jurisdiction, or D, agreed before commencement to submit to the jurisdiction. That's the test we've adopted in the DIFC, and that's the DNB case. It's never been suggested that Aria DMCC satisfies that, any of that. The necessary and proper party test gets you into the jurisdiction of the Hong Kong courts for the purposes of the Hong Kong courts, but not for the purposes of enforcement. There is no case as to how this judgment would be enforceable in the DIFC. And that's before you get to proprietary orders, because proprietary orders are not enforceable at common law. Injunctions are not enforceable at common law. Declarations are not enforceable. They can give rise to issues which can be used to found a claim, but then this court would need to have jurisdiction over that claim. which would not be the recognition and enforcement of a judgment. So there are lots of points to make, but there are, I mean, I hope I've given you a flavour of what we say, which is that this is speculative in the substance, impossible in the enforcement. And let's look at the consequences. And I've got about another 15 minutes if you'll tolerate me just a little bit further.
Yes, I mean, obviously I will give, I'll give Mr. Holloway plenty of time to respond, or light time to respond.
I understand. I mean, the thing is that on these sorts of applications, Mr. Holloway's already had his opening, if I can put it like that, which was what he said to you last time. The result of the passage of time is that the proceeds of these receipts have been used and have been spread throughout the fund and throughout the associated companies. And you've seen that in Mr. Britton's evidence. So it's impossible to point to any asset within the fund and say with confidence that is definitely not traceable back to these monies. And that must be right if the only investors in the fund now are Legacy and FTT. Management is not willing to risk contempt. And so, for example, the bitumen factory has to stop manufacturing and around 100 workers have to go home. And just think about the consequences of that. It's a live bitumen factory with dangerous materials on site, and we cannot pay security guards, we cannot pay safety technicians. We just have to leave the site as a result of that order. And the health and safety hazard imposed by that, even in and of itself, is obviously a significant factor. But why? What's the point? Mr. Britton gives some evidence about orders which need to be delivered in 2 weeks. He does that at page 1852. So there's some specific transactions which are in train. Paragraph 54, he deals with that as a $12 million bitumen order that's been placed, needs to be delivered. There's, in addition to that, just generally, there's a line, paragraph 55, there's a line of people queuing up to buy bitumen from this facility, and none of that's going to happen. And the plant will probably have to close. He deals with that, 56, 58.
Isn't the short point this? Particularly if now the only people invested in these businesses are ultimately the beneficial owners of the stable coins via First Digital, Legacy, and Techteryx itself. It's in their interest to preserve the business rather than harm it.
Well, quite. So if you accept that there is a genuine business here, however that came about, and we say that that's the end of the case, but just for today's purposes, leaving that to one side. I see. For today's purposes, if you accept that this is true evidence, and we've tried to give you as much as we can, we could do a site visit if you'd like, send someone down with a telephone. But if you accept that, and we say you must, then what is the purpose of shutting it down? What is the purpose of stopping it trading? It's going to cause harm. You're not preserving the assets. You're positively damaging the assets and causing all these other problems, health and safety, regulatory problems, which are associated with just saying, we're going to stop manufacturing, we're going to shut down a Tanzanian mine. It's just, this should have been the focus of my learned friend's submissions to you, or at least part of the focus at the ex parte hearing, because they knew that this was what we were saying had been done with this money. They pleaded it in their claim in Hong Kong, that this had been used for investment in a mine, that this had been used for bitumen plant processing. So they knew our case, our position, was that the money had been invested in all of this. And my friend should have been saying to you, well, they say that there's a bitumen plant, they say there's a mine, we don't know whether that's true. And what they might say is, if you tell them they can't use these assets, well, that's going to shut down, and that's going to actually harm the asset. But you didn't have the opportunity to deal with all of that because you weren't told about any of this. But now that you know about this, Your Honour, the obvious answer we say is to keep these things going. What you were told instead, actually, and this is the way it was put in my learned friend Skeller's argument. He said, paragraph 49. He said, well, the monies can also be transferred again very quickly and put beyond the reach of the applicant. So he gave you the impression that there might still be a pot of money sitting there when they knew that that was not the case, or at least they knew that we told them that we'd used that money. And indeed, they'd had redemptions from the profits that were generated by the use of that money. But I think you'd need to be very, very clear that there was a very, very strong case before you were going to make an order that had that sort of level of interference. And we say, actually, given the level of interference, you shouldn't make any sort of order at all. But we can live with it.
I see all that. What you would say, I guess, is that even if they're right and there is cash within the business in addition to the trading entities, the normal course of business exception would not extend to paying that away, and they would still be in contempt. That you would still be in contempt if you paid away any cash reserves that you were holding.
Yes, yeah, exactly. So we've given a list of the cash reserves. So you've got a comprehensive statement of what those are. And I think the way to think about it is like this. On the one hand, imagine the two competing orders if we comply with them, and imagine the two competing orders if we don't comply with them, and then ask yourself the question: is there actually any benefit on either case to my learned friend's proposed continuation of the proprietary order? So if we are right and we're going to comply, then we're only going to use this money in the course of business, and we will be doing that to keep the assets, maintain their value, to trade in the way that they're always supposed to trade, to generate profits. If we're not going to comply, and of course we are going to comply, and I hope you've seen what we're doing. If we're not going to comply, what's going to happen? How much additional protection does my learned friend get if my clients are just going to be contemners and abuse these monies anyway? This is not a case where you've got $450 million sitting in a bank account somewhere, which should be locked. So in practical terms, there is no benefit to even my learned friend's clients of having the proprietary order in place. There is huge detriment to us, and there is, we would say, huge detriment to my learned friend. The fact that they are pursuing this proprietary order, even now that they know what the consequences are, is to us quite shocking. Your Honour, you've tolerated me on this issue for some time.
Yes.
And I hope you understand why I've taken a bit of time to develop it, and I apologise for taking more than perhaps you wanted to give me. But it is important, and fundamentally, we say, this court should not be closing down businesses, and that is really what the effect of that order will be. If you accept that pretty much everything in this fund is infected, if that's the right word, with the money that first came in, and it is a genuine business, then it should be we should be entitled to continue it as a genuine business. I think those were my submissions. I'll be told if there's anything burning that I haven't covered and that I should have covered, but unless you've got any questions for me on that was
no. I've asked them as we've been going along.
The fortification issues I was leaving over. I mean, I would like to have a go and explain to you why we say we ought to have some fortification, even if it's just for the 6 to 8 weeks between now and the next hearing.
You're going to have a bit of an uphill task on that at the moment.
Well, I ought to have the chance, because I mean, I think as a matter of principle, a party that's obtained orders where there's evidence of harm actually the authorities suggest that there should be fortification.
Yeah, no, I see that. It's more in terms of the procedural position, in as much as I don't have any evidence to the contrary.
Well, but that's the point that I was making at the outset, which is incumbent on my learned friend to deal with all of this. He should have put forward to you that they say there's a bitumen factory, it's going to have to shut down. We might lose profit. It might lose profits. He should have brought to your attention the consequential harm of the order that he was proposing. And then he should have brought to your attention evidence of his client's capability to meet that and the confidence the court can have that it will meet those orders when they are made. That's how you do it on freezing orders. You come to the court with your audited accounts, or you say, I'm a bank and you can trust me. What you don't do is you show up as Techteryx, who has, we don't really know who the ultimate beneficial owner of that company is. It bought these rights, its interests, for a fraction of the value of the claim that it's advancing now. It says, I can't remember what the number was, but I think it was
28 million.
$28 million. We don't know who they really are, and there is live evidence before you today of the interference that it has had in the business of my client. So we will be saying, and we say there's a strong case that this whole order should be set aside, and there should be an inquiry as to damages.
Well,
this. But that comes
it's
later.
for another day. But I mean, what I think you can say now is that even if I'm against you on determining whether or not there should be fortification today, because I don't have the evidence behind all of that stuff, you can say perhaps that if I'm persuaded that it is a trading entity and that damage will be done if it stops or continues to cease trading, then the absence of fortification supports your variation application.
Well, it does.
Because it minimizes the damage that would ultimately be suffered if you're right, it's discharged and there has been inquiries to damage.
We wouldn't quite agree that it minimizes it. What has happened?
Well, if I maintained the order and you went out of business in the next 6 to 8 weeks, the losses, if you then succeed in discharging the injunction, the losses would be greter than if you were not put out of business.
It
That's
reduces
the whole point.
them.
Yes.
It reduces them.
Yes.
Would we accept that it minimizes them? Well,
No,
we'll
I
have
didn't
to
mean
wait.
that was an unfortunate.
I see. That was all.
I meant reduce, not minimize.
I see. Yes, of course. No. The losses, we say the losses if you maintain the order in its current form would be catastrophic, and the result. So I mean, we will lose laycans in Australia. You've seen all that evidence. We will probably be in breach of that contract for not taking up those laycans. So we will lose that contract, which is a valuable asset. We will have to shut down mines. We will have to expose ourselves to all kinds of potential harm. That will be catastrophic, and we will default on all kinds of obligations. There is no doubt about that. But if you amend, we've already suffered some of that loss. If you amend it, we will still be in the situation that I showed you in the ArcelorMittal case, where it is going to interfere quite substantially with the way that we do business.
No, I understand that.
Even in the amended form. So there will be an 8-week period between when the order came in, or a 10-week period between when the order came in and the full return date, which we will be completely unsecured for. And you're right, you don't have chapter and verse, but the authorities that I was going to show you, which the energy venture case in particular, just says you have to make an educated guess on the material that you have. And one way of doing that is to assess it on the basis of the usual cost of borrowing against the total value of the frozen sums, and just say, well, let's effectively require to give fortification for the impingement on your ability to trade those assets in the meantime.
Well, do you want to take me to that authority? We might as well.
Yes, all right, thank you. It's page 239, and it's in the energy venture case.
Yes, to page 239 of
Sorry, of
your
our
second. It's the second bundle of authorities. Yes, I know where to find that. Respondents' legal authorities. I'm out again.
I think we've
Yes, I have it. Okay, paragraph.
Well, we can start at paragraph 53, which is the one that we recite. I'm not going to read it out to you. Can I just ask you just to read 53 all the way down, please, to 59?
Okay, and bear with me a second.
Yeah, I think that's the best way to do it.
Okay.
So the short points there are. Sorry, I didn't show you 52, but the what's said there is that effectively there's a sort of symmetry. If you're going to get the order, you should give fortification. And what we need to show is that there's a real risk that there's going to be harm that flows. And in this case, we would say, and harm that has flowed already from the order that's been in place. But it's not going to be a scientific assessment. It's got to be an intelligent estimate. And one way of doing that.
How do you suggest I do that then?
By reference to some measure, when I don't have evidence for you precisely on this, but I would suggest that we're looking at something in the order of $2 to $3 million fortification, and that would amount to about 6 weeks at 6% on the sum that's been frozen.
So 2 to 3 million.
3 million would be 3 million would be 6 weeks at 6%. I'm not suggesting that 6% is the cost of borrowing in this part of the world. And we're not even dealing with 6 weeks. So it's not a scientific process, but they need to put something down. We say.
Okay, I got it.
I don't know whether you're
to say for Mr. Holloway's benefit, that is a more modest proposal than I thought was going to be made.
Well, quite, and I'm trying to be we're trying to be reasonable here. We're not trying to, but the bottom line is that, you know, I'm not here to ask you for $20 million.
No.
Even though that it may well be that on an investigation, that is the sort of, you know, that's the order of things. And we may come back and show you evidence that it has been higher as a result of these things. But if you were to make an order for $3 million, at least that would give us some protection in these circumstances. Does Your Honour need me to deal with the time to comply? We need an extension of time, in principle, to comply with the information order and the affidavit.
I'm not. Frankly, I'm not. I don't think you need trouble me on that. There are much bigger issues we've looked at, and particularly looking at the time, we're well over the estimate for the whole hearing, and I do need to give Mr. Holloway some proper time to respond. So I make it around 2:30 Dubai time, 10:30 London. Shall we take a break of 10 minutes? Just so for everybody's comfort. We'll resume at 20 to 11 London, 20 to 3 Dubai.
Thank you.
Thank you very much. I was just wondering if Mr. Holloway was waiting for me or I was waiting for him. You're on mute, Mr. Holloway. I was just waiting for you to join before I joined, but
I was waiting for you. I'm so sorry, Your Honour.
that's all right. That's all right. It's misunderstanding. Okay.
So I don't imagine I'll be longer than an hour, if that's of any relief to everybody. But what I want to do is really focus on the evidence that Mr. Britton has put forward and the asset disclosure that we have to date. And the reason that I want to do that is because there is a marked disconnect between that evidence and the submissions that my learned friend made on the facts. So I'm going to focus on that. And I'm going to start with the order, if I may, going back to paragraph 14 of the order, page 1462. So I think it's important to focus on the difference between 14.1 and 14.2. Now, the respondent says that they have now disclosed all the assets, 14.1 of Aria Dmcc. We don't yet have that on affidavit. We got that overnight in an updated schedule, which I believe they now say that's the total asset list. But 14.2 was the important part of the disclosure exercise, which was the obligation to set out what the onward dealings of the 456 million that were received by DMCC and where they have ended up. And my submission, they haven't even begun to comply with that part of the order. Your Honour, what they've actually done is provide a very lengthy list of what they say might be the ultimate destination of those funds, but we have really no evidence of how they got from DMCC to where it is now said that they might be. So that is a very preliminary point. But even though Mr. Britton says he's been working tirelessly with a team of 7 people, 8 lawyers for the last 17 days now, we still don't have that connection between when the funds came in to DMCC and where they say they are now. Certainly don't have that on affidavit in any meaningful sense. So I'm going to start with the asset disclosure that we have received, and I'm going to focus on the version which has been sworn, not the version that came in by email overnight, but the version that was exhibited to Mr. Britton's sworn affidavit on Friday night, I believe. And I'm going to make a few submissions on that because that asset list it is very concerning to our client. Having been able to check it for a couple of days, you'll see that there are big concerns with it. Now, just to summarise, the list, we've done the maths on it, and it seems to say, the sworn list, that the DMCC company has total assets of a value of about $29 million US. That's the sworn evidence of Mr. Britton. But the fund has a total of something like 540 million. So what my learned friend is proposing, therefore, today, is that we don't get any protection for the 540 million. The order is scaled back to the DMCC company's assets, which is 29 million, which is obviously woefully inadequate. So that's my first point on that. But second point, it's a 36-page schedule, 432 entries. 200 of those entries list assets that are below the $10,000 threshold. So it's basically padded out with small transactions that were not actually required to be disclosed. Half of the information in that schedule is not really relevant. And then,
I mean, isn't there a slight problem with the submission you're making, which is that the fund isn't a party to these proceedings?
well, I'm going to move on to that, of course, Your Honour. But what they've done is to say this is where it might have gone, and it might have gone all over the place, and we've only got a tiny bit left ourselves, and we shouldn't be, we shouldn't be prejudiced by that. You should only have security for what we have, not for the other businesses. But I'll move on to that. But these are just headline points. Of bigger concern are some of the big assets that are listed in that list, because our client's position, in summary, is that many of these aren't real assets at all. They are what you might call ghost assets from the preliminary checking that we've done, and some of these are large value assets. So I can just run through a couple of examples of that. And I'm going to look at the version of the schedule that we got, which is the sworn version. So I'll be flicking through this a little bit. I'm going to turn you to page 1830, which is page 26 of that schedule. I'm looking at the two assets relating to the mines in Tanzania, Imbuyu Mine Limited and Imbia Coal Limited. Now, those are supposed to be companies, independent companies held by the fund. We are instructed, having checked this over the weekend, that Imbia Coal power project was acquired by not the DMCC company, but Aria Capital Management Limited. That's Mr. Britton's company. But it had a kind of asset value in 2023 of 0. But yet now it's recorded on this list as an asset held by the fund with a value of $225 million. The second one, the second coal mine asset just below that, Imbea Coal Limited, Tanzania. Our client, my instructions are that they cannot find that company on a basic internet search, such as we've been able to do over the weekend, but yet it's listed as an asset of the fund worth 65 million. And again, it's not an asset, it's actually the asset is a company, a separate company, rather than a coal mine itself or any plant or machinery, which I think is significant as we move on. I'll come back to that. And then again, on that same page, Carbon Resilience PTE, which is registered as a $125 million asset. From what we've been able to discover, That is a Singapore company with 2 shareholders and a total paid up capital of $1,000 US. It has a website, but we're unable to find any identifiable operations of that company. Further, the fund is not listed, to our knowledge, as one of the shareholders of that company based on a check of public records over the weekend. So that's $125 million, which we believe is a questionable listing on the sworn version of the fund's asset list. And then there are other examples. We have at page 1814, if I can flick you back. There are 2 companies there listed, Glopet and Carestone Shipping, at the bottom of the page, listed with a value, listed as, I believe, companies owned by the fund with a value of $42 million. To our checking over the weekend, those companies don't exist or have been struck off or deregistered, as far as we know. Now, that's some highlight points on the asset disclosure that was given on Friday night, sworn after close of business on Friday. There is an updated version of that schedule that has been emailed, and I think we haven't really had time to analyse that. I got it early this morning. There is one asset, an extra asset that wasn't mentioned on the sworn version, of an Indonesian operation, apparently worth $240 million, owned by the fund. My client does not accept that that is a bona fide asset, but we need to investigate that further. And also, some explanation needs to be given as to why the first sworn version was not accurate in the respects that it's not, and why it has been changed. So just as a big picture point, our preliminary inquiries suggest that 450 million of those assets, including the ones that I've just mentioned to, are highly questionable, to say the least. And I submit that that asset schedule, which has been verified by affidavit, is not reliable, as we'll have to comment on that further, but that's my client's instructions to me today, having seen it over the weekend. And then the next document I want to turn to in similar vein is Mr. Britton's affidavit, the one which exhibited that schedule. And well, it's the same submission. We believe that that affidavit is selective, misleading, unreliable in a large number of respects, and it certainly is not an affidavit putting the first respondent in compliance with their disclosure obligations. I had understood my learned friend to say that they'd not complied with that during the submissions, but I think at the end, when he talked about extensions of time, I think that's probably not the position, and that they...
No, that's not what I said. That's not what I said. I need an extension of time because the asset disclosure list was provided this morning or late last night. But it is, as far as we understand it, it's complete. We've never had any of these. My learned friend hasn't raised any of these points with us previously.
Well, it would have been very difficult for you to raise them at any point before now, because I only got that email in the middle of the night this morning. But anyway,
he's had the list for days.
Let me cut this short. Obviously, there's going to be a great deal of issue about all of this in due course, but I'm very content to permit the respondents the time to put on oath what they disclosed by way of email this morning. Equally, Mr. Holloway, you are going to have the time to analyse that and flesh out what you're saying now with some evidence. Yes. So that Mr. Montague Smith's clients can respond to that in due course.
But on a more general point, the form of that asset disclosure and the form of the affidavit that we have is just not compliant with the provisions of 14.2 of the order. It's not enough to say, here's a long list of stuff that might be the end product of these funds. It was supposed to give a full account of the onward dealings of the funds from when they were received and to where they've ended up and how they've ended up there. That's a huge gap in the evidence, and it's a gap in my submission, Your Honour, that means that one cannot take any of the submissions that Muller and Friend made, give them any weight at all. We don't know how funds ended up from one company to the other, etc., etc. But I'll come back to that. But the affidavit is not in the form that makes it a meaningful document, an asset disclosure list that we can actually work with in compliance with 14, 15 and 16. So it's not enough just to put an updated list. The compliance with 14.2 has to be complete. The onward dealings account has to be proper. How did these monies end up from one company to the other? Where were the transfers and when did they happen? And I think when Muller and Friends clients have done that, he'll be in a stronger position to support any of his applications for variation or fortification with actual evidence that there's an asset belonging to his client that they cannot deal with because of the order. At the minute, it's silent on that. It's long on submission. It's completely short on supporting documents, and I'll explain to you why as I go along. But I'm going to come back to Mr. Britton's affidavit because there are a number of points that need to be made on that. And it's at page 1840. There are a couple of very big gaps here. Mr. Britton doesn't explain his role in the affairs of the fund. He doesn't explain in any detail the connection between the various companies that are referred to in that asset list and the various companies that Muller and Friend talks about in his skeleton argument. There's no detail at all about what the relationship between any of these entities is. So I'll start. I'll have to turn through this paragraph by paragraph, I'm afraid. I'm starting with paragraph 11. The account that he's given of the fund is misleading. It doesn't explain his role. It doesn't explain the connection between the DMCC company and the fund. And there's a big question mark about when this fund started operating. I'll come back to that. But he says at paragraph 11 that it started operating in 2019. And there are lots of inconsistent documents as to what the status of the fund was before 2021. I'll come back to that when I look at his latest evidence last night. But the 27 as the date of registration, he says it's a typo. But elsewhere in those accounts, it says that the company was incorporated in 2016. And
where does it say that?
Well, both the product placement memoranda say that.
Can you give me I know you say you're going to come back to things, but
yeah, no,
for my note, it's
take
very
you to
helpful if I have chapter and verse.
So the two product placement memoranda, first one I think is at page 264.
EPM. Okay.
Date of incorporation, it's page 3 of that document, 13th of July 2016. And the second one is at page 359. It has exactly the same date and number. 359? It is. I'm sorry. Page 3 of that second memorandum. It's in identical terms as the first
Sorry,
one.
what's the bundle number on that?
I'm trying to find that one. Sorry. Let's go to the beginning of that document. Sorry. I had it as 359. I may be wrong. It's at the very beginning of the document. Sorry.
Page bundle number 357.
357. I am sorry.
357, thank you.
Yes, the same date, the same incorporation number. And I'll come back to that because I think the accounts that have been given both in this court and in the Hong Kong court are contradictory to that. I think it is significant, but I'll come back to that when we talk about his latest evidence, which I'm going to do at the end. But I'm going to just take this through the affidavit point by point, Your Honour. So paragraph 11, and we're touching on the shareholder register here, and it's a point Your Honour has. But what it says at 11E is that the register was updated periodically to reflect the identity of the shareholders and their holdings as they changed over time. And then he says, here's some examples of that. The examples given, one of them shows the shareholders and their holdings, the other one doesn't. And then we have the latest one, which I'm going to come back to. But it's a point that Your Honour has made. The point of this is to reflect when shareholders became shareholders and ceased to become shareholders, as is required by law. The documents we've got don't really do that at all. And I'm going to come back to the one that came in overnight. But his own evidence here says there was an updated, constantly updated register, and it didn't exhibit that at all. So, as Your Honour said, we've got a selected version of it that was created on Friday, but we don't have the register at all. Then paragraph 12, this is all the evidence about the fund. It seems to be, well, yeah, he admits there that he misled the Hong Kong court, and we'll come back to that, and corrected it, allegedly. But paragraph 13 is getting into this material about the 2021 accounts. Now, it's plain that what was being asked for by Techteryx at that point were not self-generated management accounts, but actually statutory accounts that would actually verify that they had a bona fide investment in the fund. Now, my learned friend picking about the caveats to the accounts, but the caveats are important because there were two different sets of accounts filed here, Your Honour. Prepared. One of them was prepared in December 2023 and disclosed at that point. The second version is the one that we received overnight. That was not prepared until September 2024. And the caveats are different on those accounts. The reason that the caveats are different is because one of the first set was not to be filed with the regulator, specifically stated not to be filed by the regulator. The second one was to be filed by the regulator. So the caveat's important, as is the whole point of it. If you look at the email disclosing those initial audited accounts, it's at page 1768. It's important that we're looking at the answers to questions. And Campbell's answer on the second row of the first question, sorry, the second question, the fund's audited accounts for 2020, 2021 and 22. And it says the audited accounts for 20 and 21 are complete, and with the statutory auditor for sign-off. ETA of statutory sign-off is January 2024, and the accounts for 2022 are to follow. Now, that's not correct because the 2020 accounts have never been audited, and even those accounts that you've seen make it absolutely clear that there are no audited 2020 accounts. Neither are there audited 2022 accounts, neither are there audited 2023 accounts. And we have one version, and we only got it yesterday, of a set of accounts that have been filed with the regulator. We're talking about accounts in the context of a dispute that's been going on since 2021. We don't have the accounts for the relevant period in question, which is the period after the transfers were made, 2021, 2022. The accounts that we do have were filed 3 years late, and there's no explanation of that at all. In fact, they were filed very late, and I'll come back to them because we're going to talk about that. But my learned friend makes a point about the Hong Kong proceedings and the Cayman proceedings. It's very, very simple. In 2023, my client was trying to get evidence that they had anything to back up the hundreds of millions of dollars that they paid. They had to go to court in the Cayman in 2023 to try and get official documents, which were not being made available to them. Now, they didn't get them. They got these accounts from Campbell's. And at that, it's perfectly right in Hong Kong for them to say we don't have the proper audited accounts. At this point, they didn't have the statutory accounts that they were looking for. They had a caveated version that said this is not to be filed by the regulator. You've got to bear in mind, Ronald, why we're looking for this information in the first place. It's not to get a piece of paper produced showing this. It's to show that there's some bona fide standing of this fund in Cayman, and it looks like they're very delinquent in filing accounts, particularly for the period, the real relevant period in question, which is the 2021-2022 period. And we're told that that's not now coming for another few months. Why have they not been filed already? I'm going to come back to that when I talk about the latest material that's come in. But Mr. Britton then talks about the nature of the business of the fund, I believe. Again, I mean, it's something you picked up on the ex-party stage, using the word Aria, the business of Aria, generically to cover any entity which is convenient at any given time. So going back to Mr. Britton's statement around about paragraph 15 onwards, this is misleading. There's no evidence of any group of companies in any meaningful sense at all. There's no evidence about relationships between Aria Dmcc and anyone apart from the fund. The Tanzania companies, all of these other Australian entities, what is meant by a group? There's nothing in the evidence that shows what the connection between DMCC is. The only accounts we've got talk about related party transactions. That's a very wide test, but the only related party that is mentioned is DMCC company. So we know there is a connection, and we know what the connection is. It's Mr. Britton's wife. But we don't really know anything about the wider connections between any of these other entities, and this is significant. because it's an incomplete, broad brush statement that, well, we got this money and we just circulated within the group. We don't know what the group is. We don't know who owns those companies. There's no evidence of that. So then I think perhaps more relevantly, the use of the DMCC payments, section D of this affidavit. And again, this is what paragraph 14.2 was supposed to require the respondent to set out in detail. When the monies came in, where did they go? It's not good enough to say, well, there are these companies in this group that might have got the money. There's no real evidence of this. But paragraph section D2 is particularly misleading, Your Honour. Particularly, well, paragraph 25 is, in my submission, misleading as a whole. It says documents were created in relation to each DMCC payment. It does not say who created those documents, and it doesn't say when they were created. And the exhibited documents, which are said to be examples of the kinds of documents that are talked about, just don't support that at all. That's a completely misleading by omission statement. Particularly misleading is paragraph 25C, Your Honour. It seems to be suggesting here that the monies were transferred as part of a trade finance facility between FDT and Aria DMCC. And then again, we have a reference to an exhibit supposedly supporting that. But that exhibit doesn't say anything of the kind. It's a sample trade finance document. It's unsigned, it's undated, it doesn't mention either FDT or Aria DMCC. So that is, I submit, a misleading piece of evidence. The idea that the monies were paid pursuant to this kind of loan agreement is just unsupported. Neither is there any evidence that Aria DMCC lent on the money. Sorry, I'm just trying to get the page reference for that exhibit. Your Honour, if I may, can you bear with me? Page 157. It's probably worth looking at because I think it's symptomatic of
Page 15.
It's page 157 of MWB2. So that's the, I believe it's 2017. Sorry, I should have written that down before. So yeah, this is, yes, this is the document that's supposed to evidence a finance agreement between FDT and Aria DMCC, but it's a sample document. It doesn't have a date, it doesn't have a signature, it doesn't refer to either of those two parties.
I thought FDT was buying shares.
I think FDT probably thought that as well.
FDT was buying shareholding in the fund, not lending money.
Yes, well, there's no evidence to suggest that they were lending money. This is in my submission, just nonsense. It's an explanation that isn't backed up by any contemporary. If there was a loan agreement and a trade finance agreement, it would be there. You don't produce an example document. That's I'll move on. The next section, again, he says section D3 seems like 450 million of the funds were loaned to various entities. Aria Australia loaned via a US entity. A loan of 100 million was given to Aria Bio in the UAE. There's no evidence of any loans or agreements. No evidence of who sent the money, when, where, and what the legal basis for doing that would be. It's just simply another way of saying the money has disappeared. It's been spirited away to other companies. There's no supporting evidence of that in the affidavit at all. There's certainly no reference to any. And then we get to the story about porting the money back to the fund, which is at D4. And this is, again, basically stretching credulity. First of all, it seems to be accepted in paragraph 31 that in December 2022, it was realised that there were no holdings recorded in the fund at all. Then what Mr. Britton says, there's an account whereby he says a suite of documents was created, paragraph 32. They realised at the end of 22 that there were no holdings in the fund at all for FTT. So they set about creating a suite of documents to kind of somehow backdate the holding. Now, there is no suite of documents making any mention of porting monies back to the fund in the exhibit to this sworn affidavit. Now, there are some email exchanges between Mr. Chalk, Mr. Britton, and Mr. Jare, and they're at 1926. And I think at the bottom of that, there's an email from Mr. Britton, lower down the page, where he talks about engineering what he calls a reverse share split in 2022. So this is reverse engineering, backdating documents to reflect things that didn't happen in 2022. And my lord, if the attachments to those emails, it's not clear what's been exhibited here, but if the attachments to the emails are the suite of documents that he's referring to here, then this is deeply troubling evidence. I'm going to look at page 1928 here. Is this 1928 and 1929? If this is the document that's been engineered to cover up from the fact that there was no holding in the fund, this document is dated 2021. It is not dated late 2022 or early 23. So those documents, the document trail, look on their face. If these are the documents that Mr. Britton's referring to for this reverse engineering, they look like they're incorrect, they're inaccurate at best, and they don't reflect what Mr. Britton says they were. So they're not documents dated 2022 saying we are regularizing the holding. They're documents dated and signed in 2021, which can't be right. Now, that's the exhibit. I'm dealing with the exhibit to the statement as it was presented, and there are big question marks there. It may be that that's been wrongly exhibited and so on. But in any event, the story is deeply implausible on its face. And the documents don't seem to back it up at all. Now, next he talks about the securitization process. I'm not going to spend too much time on that, but I'm instructed that those kind of promises have been made for a long time, and really, there's no evidence at all that the order has had any impact on that at all. There's no evidence that Mr. Britton's been prevented from presenting a securitization process In fact, the order provides that it would be discharged if adequate security were to be provided. We just don't have any reliable evidence of any plan that could be sort of reasonably accepted to give security to Techteryx. And then perhaps most relevantly here, I'm going to talk about my learned friend's submissions about the damage to the alleged damage to his client's business. And he's used my client's, he's referred to Aria, the fund, as his client in his submissions, but his client, as far as we know, is Aria Dmcc. There's no evidence of damage to the business. And indeed, the evidence that has been submitted is misleading. Again, Your Honour. I'm looking at paragraph 54. I'm looking at the actual evidence. Page 1852. Your Honour, Aria Dmcc does not own a plant in Hamria. It just isn't the owner of that plant. It's not listed on the asset schedule. It is not the owner of that plant. And the only plant that's listed for Aria Dmcc on the asset list is a car and some asset office equipment. So there's no evidence that they own a plant at all. That's misleading. It is not Aria Dmcc that owns the plant. There's no evidence of a contract to sell bitumen between Aria Dmcc and anyone. That's just assertion. It would have been very easy to provide those documents, and you would have thought that it would have been the basic thing to do. So there's no evidence of an inventory of $12 million of bitumen on the asset list. And there's really no evidence of this order preventing anyone from doing anything of the nature that's been complained about. There's no evidence that the bitumen plant needs to close. And Your Honour, the bitumen plant, as far as we believe, is owned by Aria Bio, which is a separate company. We believe it's wholly owned by Aria Dmcc, but there's nothing in the order. I mean, Aria Dmcc are prevented from selling that company. There's nothing in the order that stops Aria Bio from trading the plant, or there's certainly no evidence of that. Neither is there any evidence that the order would cause any problems to these Australian or Tanzanian entities or prevent them raising security. Those are assets, different companies. And if Aria owns those companies, it's not allowed to Aria Dmcc owns those companies, it's not allowed to sell them. It doesn't mean those companies are prevented from trading. So the evidence about damage is actually in no way more believable than any of the rest of it. You know, there's a huge step missing here, and what's missing is proper compliance with Article 14.2 of the order. Where did the money go, and how did it get there? And if we're not going to get that from Mr. Britton, we'll probably have to get it from the banks in the end. But I'll leave that there. I'm just going to make a couple of points about the latest evidence that came in last night. And I'll have to just be guided as to the page numbers, but it's the second witness statement, and significantly, this is not sworn evidence, but there are a couple of misleading points here as well. I'm going to pick them up. Paragraph 21, I think it's page 2401 actually.
Sorry, bear with me. I keep on getting locked out of.
I'm sorry, Your Honour. Yes.
No. It's a fault in our system. So we're now looking at the second witness statement. Is that right?
Yes. So this is, I think, a clarification of the affidavit, but on on statement form, and he says, to the extent that I need to clarify the second sentence about
Where are you reading from?
Paragraph 21, I do apologise.
All right, okay.
So here he's explaining the discrepancy in terms of when the fund actually was operational. And here he says, yeah, I was referring to the operation of the fund as a licensed fund. Prior to that, there was a private exempt fund, but that is not really a clarification that explains things. If you look at what he actually said in the Hong Kong proceedings, it's at 1712. And paragraph 14. So in those proceedings, he was saying, I couldn't give financial statements because the fund wasn't operational then. And that's not true. It was operational then. It was just slightly different as a legal entity. And it's not good enough to say, oh, I only meant that it wasn't operational as a sort of one entity rather than the other, because in that first affirmation, he was saying that's the reason I cannot give you any financial information going back beyond further than 2020. Now, there's a huge question mark here, and it's actually important, Your Honour, because there is lots of evidence that the fund was operational before then, including the fact sheet in April 2020, and that fact sheet represented that the fund was operational, licensed, etc. So it's a continual obfuscation of the picture. We don't have.
We've got a PPM, haven't we, in
Yes.
June 2019?
Yes. And indeed, I think Ms. Lee's second affidavit highlights this. Both of those PPMs say on their front page that can we get we should,
Page 204 of the bundle.
thank you. You're always ahead of me. On the pages. No, it's.
No, it's not. I've got two. I had 204.
I'll find it. It could be one.
Maybe it's 240. 204. Maybe 240. Maybe I made a mistake.
It's
Two.
First one is 258.
258.
258, is it?
Yes. So incorporated with limited liability under the laws, the Cayman Islands, June 2019. And that's
June 2019.
you got.
Oh, 204 was the exhibit number. Yeah, 258 is the bundle number.
What's that? Yes, sorry, the April fund as well at page 348. The note.
348.
Predates basically that point. So it also shows performance on those graphics going back to.
That's the fact sheet, yes. Yeah.
Yes, May 2019. So, question: why have the 2020 accounts not been submitted to the regulator? Why have the 2022 accounts not been submitted to the regulator? Why is this one, the 2020, June 2021, the only one we've got? And it's the only one we've got because we've had to go to court twice to get it, and also it starts and finishes at a period before all this large amounts of money came in. So they've reluctantly and slightly misleadingly disclosed the irrelevant audited account, and we've got no explanation as to what was going on with the fund. So that point one, I believe that is misleading evidence. And then secondly, they've now produced finally the 2021 accounts that were sent to the Cayman auditor. A couple of points on that. If we look at,
where do I find them?
yes, question. This is all very late in the bundle, but it's 2.3. I want the, it should be at the very end of the bundle. You know, and I'm just looking at paragraph 23 of those accounts. So it is note 23.
Do you have a page number for that?
I'm guessing it's been scrolling, but
23 is 2529 is the note, is the subsequent event.
yes, 2529. Yeah.
2529.
So remember, we had the internal version, which was disclosed at the end of 2023, and then
bear with me a second while I get that. I'm sorry, my bundles are split all over the place. You have to bear with me. So that will be a 14th March filing, and part 3. That's it. Part 3. Do you have the internal page number of
yes,
NB2 and WB2?
125.
I'm so sorry.
It's MWB3, page 125.
MWB3 125. Okay. I do apologise for being slow. I finally got there. Thank you.
So it's just, I think there's a big difference between the so-called audited accounts that were submitted in June 2021, that we had at the end of 23, and this one, which we got last night, which appears to be sent to the regulator, is this subsequent events, para 23. And what's been added in between the end of 23 and the end of 2024 is this idea that afterwards extra subscriptions have come in for $500 million. That's come in to those accounts last year after they were first audited. And in my submission, that's misleading in the sense that no mention is made of a very significant subsequent event to the 2021 accounts, which is that there are court proceedings in relation to that subscription and that that the fund was being sued for fraud in relation to those monies. That's so. Just in summary, I submit that the concerns you had about Mr. Britton's evidence at the ex parte stage have been amplified and more than justified, and should be exacerbated by what you've read in these latest documents. I submit that the affidavit is misleading to this court, that the Hong Kong court has also been misled as to the inception of the fund, and that the regulator and presumably the auditors have been misled as well. So I'm going to turn first to the variation application, not application or request or proposal, I should say. They've not made an application, but even if you were minded to do that, Your Honour, the evidence just doesn't support it. And that I say that because of the complete lack of evidence of any connection between supporting evidence of the disruption that's alleged, or any connection with the order, or indeed any connection with Aria Dmcc. The quality of the evidence that you've got is also very questionable, but it certainly doesn't support any of the submissions that my learned friend made of the catastrophic effect that the orders had. And given that this is a proprietary claim, and given that we are the only person with an interest in the fund, it's quite obvious that the balance of convenience tips very squarely in favour of my client. This money seems to be ghosted away without any proper explanation, and that's $456 million of prejudice. Aria Dmcc looks like they have $29 million of assets. What's going to happen when the order releases the rest of it? He says it'll all be very catastrophic for the bitumen plant. They don't own the bitumen plant, and there's no reason why the bitumen plant can't continue trading. But it's certainly not a proper application. It doesn't have credible evidence to support it. It's speculation. It's hyperbolic submissions, and to really focus on the evidence that's before you. And I'd say the same about fortification. I've put a number of authorities in the bundle. It's not enough for a respondent to simply turn up and assert that there is a risk that some harm might be done. They have to show with real clear evidence there's a risk, the nature of the risk, that it would be caused by the order, and the quantum of that risk. You've got nothing like that before you, Your Honour. I can take. I will perhaps just give you those references, if I may, rather than go through it. But that's in my submission, that's the legal position. Real evidence is required. So I'll start with Stephen G. No, I'm going, because we put all this in this morning because the application was made on Friday. I'm going to perhaps take a little bit of time to give you the reference, but it's paragraph 1129, and I'm going to need 2669, I'm told.
Of what? Sorry.
Stephen G, paragraph 11029.
11.0, yes, but what you said 2669. What's that?
That's the bundle reference. Can you show me when that is?
2669.
Yeah. Yeah, but where?
It's in page 2670.
Okay, 2670, I think, is where the passage I wanted to start with. It's a matter of discretion for the court, and then there are three things that need to be assessed. That's correct, and I think Muller and Friends put that test in. But then the paragraph after that.
Sorry, bear with me a second. To 1129. June 21.
So it's 11029, I believe, is the.
Yes, got. Ah, there it is. I found
So
it.
whether.
Tab 27. Yeah. Okay, I have it.
I think it's just underneath those three things. I think just the emphasis is all three items require proof. Assertion of risk is insufficient. There must be some real evidence, and we would say not real evidence of the possibility of risk, but real evidence of causation and a link between the order and the alleged disruption and so on. And if Your Honour, there hasn't been proper real evidence of that at all. I mean, the bitumen plant isn't owned by either of the entities that Muller and Friends been speaking on behalf of and isn't mentioned. So there's nothing shutting them out from making a proper application on that with proper evidence. And if it really is urgent, the court can accommodate it quickly. But I would submit you haven't got real evidence, and we've certainly not had a chance to respond to put our side of the case on that. So I would submit that this is best not ordered today. So that's really the submissions on the 2 points. I had a couple of points on the merits, and I know that Muller and Friend isn't actually challenging the order. I did want to come back on some of them if Your Honour wants to hear them.
No, I don't think so.
In light at the time, perhaps not. We would say very, very quickly, I cannot see how he can say that we do not have an arguable proprietary claim. I took you through the agreements. Trustee was written in more than one of them, and fiduciary.
No, it wasn't.
Yeah,
That's false. It was in recital A, which referred to two other contracts.
perhaps what I was going to say is I didn't talk about other places where it's mentioned in the client agreement. For example, it is also said that the services offered by FDT include trustee and fiduciary services, but the agreement, I think, cannot be interpreted in any other way than that these are trust funds. But I can put the case, I can put our case simply, Your Honour, if you wish me to. We have three limbs to this argument. Number one is that when the coin holders exchange the cash for coins, we become the owner of the cash, and it was passed to FDT on trust for us, with residual contractual rights for the holders to redeem them. If that's not right, there's an alternative argument that we held the rights on behalf of the coin holders, and FDT was a sub-trustee on behalf of us. And then the third argument is constructive or resulting trust, based on the idea that the purpose of the investment failed, fraud, etc., etc. Muller and Friends says, well, we only dealt. I think Mr. Britton says we only dealt with FDT. We didn't deal with Techteryx, so we wouldn't have known that these are trust funds. That's. I mean, it's obviously a matter of fact in the Hong Kong proceedings. But the clue is in the name, isn't it? FDT. T is for trust, Your Honour. It's a Hong Kong trust company. That's what they do. They hold monies on trust. It's not really open, Mr. Britton, to say, well, I got all these monies from a trust company, but I didn't know that they were held on trust. But that's an argument for another day. I just simply submit that it cannot be said that the proprietary claim is unarguable. That is an argument for another day, and I look forward to that. The other point he mentioned is on jurisdiction. Your Honour, I don't accept that we put the jurisdictional test wrongly. We put the test correctly. Firstly, I don't see that my learned friend is challenging the jurisdiction of this court to make an order of this nature. But secondly, the test, I believe, was set out properly in my skeleton argument at page 1336 and 1339. I did mention that there would be a defence on jurisdiction in the Hong Kong courts. I did start to speculate about those proceedings, and Your Honour reined me in and said there was no point to do that. But I think, Your Honour, you expressed the point properly in the transcript, page 1556. You said the only basis on which this court can make an order is if it was so minded were to prevent the proceeds of any judgment which may be recognisable in enforcement in this court from being dissipated, subject, etc., to the proprietary claim. That's correct. That's the way I put it. I shouldn't have talked about what was going on in the Hong Kong proceedings, but it's not. It's just not arguable that you don't have jurisdiction to make this order. The rules provide you the authority to do it, and also the new court law, if I may, at paragraph 15.4, and we've put that in. I think I should refer to it. 2646. And I'm looking at Article 15.4. 2664. 2654. I beg your pardon. So, under the old law, we had to go through the hurdles of looking at Article 24 of the court law, that there would be a ratifiable judgment, and put it together with the rules and so on. It's much simpler now. You have jurisdiction, Your Honour, to make an application of this nature in support of foreign proceedings where suitable precautionary measures are being sought within the DIFC. Now, whatever happens, we don't know what's going to happen in Hong Kong. We do know that the respondent has engaged with those proceedings. He's engaged the services of junior and leading counsel. He's fought the jurisdiction issue hard. We don't know, and we can't assume that they're going to boycott these proceedings afterwards. But even if they did, Your Honour, there would be, if Techteryx prevails in these proceedings, there's a judgment in the Hong Kong courts that we're owed that money and that those are our assets. We would be seeking to enforce in the DIFC against those assets. We'd be entitled to do so. That is an argument for another day. It's a convoluted argument that my learned friend has raised, but I submit there's absolutely no doubt that you have jurisdiction to make this order if you deem it appropriate. And then I think there are two final points. I think my learned friend sought to persuade you that the test, serious issue to be tried, is higher than it actually is. Although I set out that test properly in the skeleton for the return date, and it isn't any higher than that. And also I referred in my skeleton to the Lamarck case, saying that questions of balance of convenience, good arguable case, once you have a proprietary claim, once it is a serious issue to be tried, it is almost inevitable that the court will consider the prejudice suffered to the claimant as irredeemable if the defendant is allowed to use the assets, and that balance of convenience follows unless some strong reason can be shown to the contrary. Now, I do accept that it is open to my learned friend to say there is some room for argument on the balance of convenience, but there's just been no evidence of that at all. The balance of convenience completely is in my client's favour. If they have an arguable claim to these funds and they've disappeared, really that the 12 million bitumen order, which we don't know anything about, pales into insignificance, Your Honour. So that's all I had to say. If I may just check if anybody wants me to say anything else.
Do you
Yes.
have anything to say about fortification?
I thought I'd said it, Your Honour. The evidence just doesn't support a fortification application. It's the same problems with the evidence, and I think I said it that.
Yes, yeah.
I did need to talk about the variation that we seek to the order in relation to the legal fees. Your Honour, you'll have seen that 17(1) and 2 of the order were phrased slightly differently. So they were allowed.
So what do you say about the legal fees?
Well, we say that arguably these are proprietary funds, and the law on this is that in order to be allowed to spend what is arguably our money on legal fees, a respondent has to do two things. First, they have to show that there are no other funds available to them, and second, they have to show that there's a sort of balancing exercise because they cannot spend any other funds on the legal fees. The court has to engage in a difficult balancing exercise to work out what is fair and what isn't. Now, Quinn Emanuel have said to us in correspondence that they are instructed that the fees do not represent the proprietary funds. And I'm afraid I just don't see how that could possibly be right, or what possible checks they could have done to make sure that it is right. But so we say that paragraph 17 of the order should be tightened so that the respondent is not allowed to spend more of these funds on legal fees. And just as a sort of caveat to that, they've already spent.
So what do you mean by that? So what wording are you proposing?
That the 17(1) wording is amended to be in identical form of 17(2), in that they are not allowed to use. Let me get the order. Yes.
I think you want, once the words added, however, this exception does not apply to any assets subject to prohibition in paragraph 7
Yes.
of the order. He wants that
Yes.
added to 17(2), as far as I understand it.
Yes, indeed. And that's, I think we've put the case law in support of that. It's Fitzgerald and Williams. There's a two-stage exercise to be gone through, as I've said, in order for them to be released, to be allowed to spend what's arguably our funds on legal expenses. They've got to show you, number one, that they've got no other funds available to them, and number two, that it'd be really unfair to prohibit them from spending some on legal fees. And they've already spent $700,000 on legal fees, as we understand it. And my submission is they haven't got past the first stage, and it's very difficult to see how Quinn Emanuel could be satisfied that the funds that they're spending on legal fees are not proprietary funds. So that was the last point I wanted to make. Thank you.
Anything else you want to say?
No, thank you very much.
Mr. Montague-Smith, there are a couple of points I think that I would like to hear you on. The fact that the trading entities are independent companies, I think, is a substantial point. and I don't think you had addressed the variation on legal fees in your submission.
Understood. Just so on the subsidiaries, you will have seen the latest disclosure statement, I hope, and you will see what it says there on page 36, which is that Aria Commodities Dmcc owns and then has a series of company names, and they include Aria Industries, Sharjah, and so forth. So the point is that that if you accept that there is evidence that this initial funding, this initial money has gone into all of the assets within the broader fund, including subsidiaries like Bio in Sharjah and the entity that owns this company. I mean, if you don't accept that, then where are you? What are we talking about here? What are we doing? Because where is this money? What's my learned friend's case as to where this money is going?
Let's work on the basis that he has an arguable case, or whatever the test is, and I'll obviously apply the proper test. But let's assume that he has a case for an injunction. His argument is that that injunction would not prevent those subsidiaries from trading.
But that can't be right, because the subsidiaries and everything they own are derived from the monies that went into the fund in the first place.
But they have separate legal personality.
But they're under our control. So we cannot let them, on the face of your order, use any assets which are arguably derived from the initial funding, which would include everything in their bank accounts and all of their property. So Mr. Britton will, on one view, and it's difficult to say how you deny this, would be in contempt as an officer of Aria DMCC if he gave any instructions or allowed, for example, this subsidiary to complete the order for bitumen.
So in other words,
you say,
yeah. So in other words, you say that if the claimant does have a right to trace, that right to trace arguably would go into the assets of the subsidiary companies.
Yes, but also to the assets of all over the fund. And Mr. Britton, who's an officer of DMCC, is also I think the investment manager. I'll be correct, and I know that there's been problems in relation to how he's been described. Someone will tell me if that's wrong, but he's essentially has oversight in relation to all those other entities, and including the mine. So he can say, and he has said, everything has to stop, because the court in DIFC has told us we're not allowed to use the traceable proceeds of those initial funds. Now, why are we arguing about this? My learned friend seems to be saying that the order doesn't prevent us and the group to operate in the ordinary course of business. That seems to be his argument. If that's right, give us an order that says that. I mean, what's the difference between that? The difference between that is that we have to work in a shadowland where we don't know whether or not a particular trade is going to put us in breach of this injunction, or whether Mr. Britton is going to be hauled into court and told that he's in contempt because he allowed the mine to continue working. If the answer is we can operate in the ordinary course of business, then that should be the order.
Yes, I see.
But just, I mean, there's an enormous amount of other things. I mean, as to the variation in relation to legal expenses, I mean, if we get to that point, we are in catastrophe scenario anyway, quite frankly. But the point is that if it's right that there shouldn't be a proprietary order, then of course it's right that there shouldn't be. I mean, the issue about the exception just doesn't apply. I mean, if you're against me and you maintain this proprietary order, I'm afraid we're just going to have to try again in front of the Court of Appeal, because there's no other way to go here. There's no other way out for my clients. They just have to shut those plants. And so there aren't really any sort of supplementary submissions in relation to that. It all stands and falls together. My own friend's submissions on jurisdiction were just so incoherent. I'm not suggesting that this court lacks jurisdiction to make this order. I've never said that. It's not about this court's jurisdiction. It's also not about the Hong Kong court's jurisdiction under its own rules. The point is, when it comes to a claim to enforce a judgment that comes out of Hong Kong, the test on the substance of that claim, not this court's jurisdiction to hear the claim, but the test on the substance of that claim is undoubtedly, did my client submit? Was it present? Did it agree? Did it claim or counterclaim? Those are the four bases on which jurisdiction of the foreign court is established for the purposes of enforcement. My client, my other friend makes no submission to you that my client has submitted, has agreed, or was present. He's got no case on the enforceability of that order in this court, other than just to assert, well, this court will have jurisdiction. That's a totally different question. Of course, this court will have jurisdiction. The question on the substance of that claim to enforce that judgment.
But what if the Hong Kong court decided that it did have jurisdiction over your client and then issued a money judgment?
Well, then this court could not enforce it unless my client submits, agrees, or is present. That's just the common law test.
Okay.
If there's a treaty, the test is under the treaty. If there's no treaty, it's the common law test. And I showed you what the common law test is. Yeah. And that's why, you know, if Your Honour remembers the ACC case, where there was I think it was a Kuwaiti judgment, and the whole question was the Kuwaiti courts. I think it was. Your Honour will remember that well because we were on the opposite side of courtroom in that one. But in that case, the Kuwaiti court had issued a judgment, and the question became, under the common law test, did the court have jurisdiction? And it all came down to whether or not the defendant had submitted. And the issue, if you recall that case, was because they'd taken a point on jurisdiction and at the same time taken points on the merits, whether that constituted submission. And the Court of Appeal found that in the current case, they couldn't decide that it did because the point hadn't been raised below before Your Honour's involvement in the DIFC court. And so they did not enforce that judgment. They refused to enforce that judgment. So it's not enough, and I can hear whispering. I just asked my learned friend to mute, please. It's not enough to get a judgment out of the Hong Kong court. It has to be enforceable in the DIFC. And the only way that's going to happen is if there's presence or submission or agreement. My learned friend doesn't have a case on that. And instead he obfuscates by saying, well, of course, this court's got jurisdiction. Well, that's got nothing to do with it. Of course, this court's got jurisdiction. That's not the issue. So at the moment, as you're facing with this, quite apart from the problems on the substance, my own friend does not have a case, an arguable case, as to how this order would be enforceable in your court. And he tried to get around it in the ex parte by saying, oh, well, it must be, you know, if we can't bring it there, we can bring it somewhere. Your Honour referred to that as a dangerous submission. You said you had to be satisfied that the judgment that came out of this court could be enforceable in this, Hong Kong could be enforceable in this court, and you cannot. But my learned friend, I mean, when one gets to the substance, my learned friend is just making things up on the fly. It's quite extraordinary. It's not the way to advance a fraud claim. So, for example, he says now, for the very first time, oh, well, we've got three ways we put our beneficial ownership or our proprietary interest. And one is that the holders, when they deposit the money, it becomes ours and FDT holds it. And he doesn't show you any documents. He certainly doesn't show you any pleadings in relation to that. The pleadings don't say that. The documents don't say that. He's just making it up. And then he says, oh, well, how are they supposed to know? Well, it's obvious the clue's in the name because it's got the word trust in it. He's making that up. That is the best he can do. But that's not enough because we have to know not only that it's held on trust, but that it's being applied in breach of trust. What is his case on that? He doesn't have one, as far as we can see. It is an extraordinary way to put forward a claim. And so what you get instead is just a litany of complaints, of forensic complaints about the evidence that you've been provided with, some of which they've had this information for days, and yet they haven't made these points to us previously, at the same time as saying, well, you need to be racing to do all this stuff, not only responding to this freezing order, but also, and proprietary order, not only gathering all that information, but also getting it out in a form that we're confident in. Because obviously the risk is not disclosing something we don't want to go out. The risk is in saying something that turns out to be wrong, and we're trying to be accurate. So I don't have answers to all of the questions that my learned friend has. But I mean, some of them is just pure assertion by my learned friend on no material whatsoever. Ghost assets. So he is suggesting that the bitumen plant doesn't exist. Fine. So we'll have to come back in front of you with that video evidence. We could do a site visit if you'd like. Why don't we organise it? We'll all go down there and have a look around and go around the offices. I mean, how does one prove that a hedge fund and all its subsidiaries exists? It's extraordinary. And what he does is he says, oh, well, that doesn't quite fit with this. And, you know, and he consistently describes things as misleading, but never actually tells you what it is that has been said that is false. Misleading is an implicitly false statement. It implies something that's not true. But he doesn't tell you what that statement is, doesn't show you any evidence to contradict it. And you know, I hesitate to try to engage with all of those many points, but many of them we suggest just don't work at all. I mean, there's things about the date of incorporation, for example, and it's suggested that there's an inconsistency between the PPM, which says 2019, and Mr. Britton's evidence. But the PPM that you were taken to shows in terms that it's explaining that it's an exempt LLC that's being invested in. And Mr. Britton's point was, well, when I said that, what I meant was there was no requirement for regulation prior to 2020. So all of these points have explanations, but we need to see them first to be allowed to give evidence in response to them before we can actually give you chapter and verse in relation to all of this. And ultimately, where do those points go? I mean, what is his point? Where does it all go? You said this, your accounts are late. Where is that going to? Is it going to saying this is a sham fund? In which case, how does he get around the fact that Mazars have gone in, investigated the company, and have said, yes, we sign off on all these accounts, including by reference to the NAV statements that come through from the companies that he says, oh, well, we just don't know whether they're associated with the fund at all. We don't know if there's any real arrangements there. All of that, of course, is investigated in the course of the audit. Otherwise, the auditors expose themselves to liability and you end up with a claim like KPMG. And he doesn't say a word either about the redemptions.
Yes, I mean, what's troubling me slightly, and we're going to have to deal with it at the final hearing, is actually what are the assets of DMCC, who are party to these proceedings, and what are the assets of the fund who are not party to proceedings?
Well, so we've done that in the list. What we've done, if you've got that list, so there's, I can't know how many lines there are to that.
Yeah.
But there's 488 lines, and then there's a list of subsidiaries. So what they've done is they've highlighted in blue the assets which are directly held by DMCC, but then they've also identified the related parties, so the fund more generally, and identified the assets of those.
So so just to help me, in very high level, so DMCC actually has interests in the various trading subsidiaries, and the fund then has what, receivables from DMCC?
Yes, as I understand it, the headline is, so Mr. Britton explained this in Hong Kong. The fund lends money to these related entities in exchange for returns which meet the investors' coupons that are anticipated, or the returns on those.
So,
And
in other words, the fund itself is merely itself a funder.
well, I mean, in essence, I suppose that's probably fair. Yes, its assets are in the receivables from the other companies.
Yes.
And so, that doesn't leave it unsecured in the sense that it can always step in bankruptcy or whatever. But the point is then the reality then as a result is that the funds, when they're ported back to the fund,
Well, I
they
don't
go out
understand
to
what ported means as a legal concept.
there was an agreement between the investor, FDT, and Legacy on the one hand, and then between the fund and the entities on the other, including DMCC, that sums that had previously been advanced to DMCC would be treated as investments in the fund. And so that was the position that was regularized subsequently. And that is when the shares in the fund were issued, and when those parties became investors in the fund and therefore shareholders in the fund.
So a shareholder in the fund is buying a chunk of the debt due from DMCC to the fund.
They're buying a chunk of the company which owns the debt.
Yes.
Which is
So it's wrong. It's wrong to say then, as Mr. Britton did, that FDT lent money to DMCC. It didn't.
Well, that depends on the terms, because initially the investment was direct to DMCC. That was where the porting regularized.
Okay.
So he explains that in his evidence, and someone will precisely tell me the terms on which.
No, I need
happened.
to reread it, but I just need to get the context in mind.
No, right. So what happens initially? And he explains the rationale why there were some fees associated with it. And there was concern about slow payment of those fees. So FDT initially invested directly in DMCC.
Okay.
And that's why the money went from there initially. And then subsequently, what happened was that it was agreed that those investments would be treated as investments in the fund rather than in DMCC. And then they would receive contracts, and they would receive interest in the fund in exchange for those. And that was then regularized in that way. That's how that worked. So that's why there's talk about investment in DMCC or lending to DMCC. There was at one stage, but then subsequently that was amended, and then they became shareholders in the fund. And then after that, when Techteryx arrived on the scene, after that, then they have said all along, well, we now are entitled to our redemptions. So they pursued us for redemptions, and we said, well, no, you're not FDT, and we'll deal with FDT. But by the way, now that we know that Techteryx is in the background, we've got to do all these other KYC checks. So we've redeemed the other investors, but we cannot redeem them in cash. And so the securitization process is undertaken. And this is, again, my learned friend's submissions are extraordinary on this. He says, what's securitization got to do with it? First, there is a securitization note. So you'll see a securitization note in the bundle. It's at page 2108 for $42 million. I can't tell you precisely which accounts that relates to. But this is not about giving security. Securitization is not about giving security. It's about conversion of a business into securities.
Yes, yeah, and
taking the assets off our balance sheet. So my own friend says, "Oh, well, you don't have to stop that." Well, I mean, that's what securitization is. We have to deal with the asset. The idea that we don't have to deal with the asset to securitize it is just obviously nonsense. It's very difficult to understand some of these submissions. Anyway, so I mean, the bottom line is, as we have told them in Hong Kong, as we are telling you here, the money has been used for investment. I mean, what is my learned friend's case on where this money is? Is he seriously saying it's still sitting there in those 4 accounts that it went into? Is that really his case after 4 years, 3 years, 4 years, depending on which bit it is? I mean, obviously not. And so unless this is all just a massive pack of lies, it has been disseminated through the group. And the result of that, given that DMCC, the position it holds as a parent company to many of the group companies, but also the position that Mr. Britton holds as being in charge of where things go, the result of that is if we cannot use the assets, which are the traceable proceeds of those initial investments, we have to shut down the fund. That's just a logical consequence of those two facts.
Okay.
And now my loan for is that's not the consequence. If it's not the consequence, then we need he's not obviously objecting to the business use exception at all.
Okay.
Your Honor, may I just check my notes, because there was a lot
Yes, of
that
course,
your
yes.
friend came out with. And the only other point just on fortification, I mean, it's just not realistic, his position. You don't need chapter and verse on this. It doesn't need to be scientific. You do have evidence of harm, that is specific harm that's occurring, and you can just draw your own conclusion. That generally speaking, you don't get freezing orders against an entity which is at the centre of a significant group without giving fortification. And just unless you're a bank, in which case you can be trusted to be good for the money. Unless you can show that you're good for the money, you have to fortify. The only question is how much. I think those are all the points I wanted to make. If that's
Okay, well, thank you very much.
Thank you.
What I propose to do is, in view of the urgency, let you have an order today. That's today English time, so it may be after hours Dubai time. Clearly, the current injunction will stand until the further order, but it will be, as I say, within today English time. The reasons will follow, I hope, tomorrow or the next day. They will be fuller than I had anticipated them being, having deference to the very full and researched arguments that have been put in by counsel on both sides. So that's where we stand. From the business point of view, the parties will know where they stand today. From the legal point of view, if it's decided to review my decision, that material will be available within the next 48 hours.
It's very helpful. Thank you.
Thank you very much indeed, and thank you both for your arguments.
Thank you.